ಡೌಟ್ ಇದ್ರೆ ಮೆಮೋಸ್ ಏನಾದ್ರು ಮಾಡಿದ್ರೆ ಲೆಫ್ಟಿಂದ ಫಸ್ಟ್ ಮಿಷನ್ ಮಾಡುವಾಗ ಮೀಟ್ ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
Any mentionings through video? Any mentionings through video?
Serial number
Any
22, madam.
memos? Yes, please.
The matter is to be posted for admission. However, interim order is in operation and we have to file paper books for that. It may kindly be.
Conscious kindly, my lord, the matter was dismissed for non-prosecution by the Honorable Registrar P&H. My lord, matter, we have filed a recalling application and we have complied with all the office objections. May be posted for hearing on IEA.
For those are interlocutory applications for recalling, memo need not be filed. Registry and particularly Registrar Judicial has been strictly warned that the moment the office objections are complied with, without delay, the matter to be listed. Yeah, they will list it. Yeah.
Matter for admission, 2021 matter. Suit for partition, suit is decreed, and for the respondent.
What is the urgency?
Additionally, FDP proceedings has been stayed, madam. Before the trial. FDP proceedings stay ಮಾಡಿದ್ದಾರೆ ಸರ್.
ಹೌದ್ರಿ, ಇಲ್ಲಿ ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇದೆ?
ಅದು ಆ ಮ್ಯಾಟರ್ ಅಡ್ಮಿಟ್ ಆಗಿಲ್ಲ.
ಅಡ್ಮಿಟ್ ಆಗ್ಲಿ ಬಿಡ್ಲಿ, ಬರ್ತದೆ ಅದು. Appellant concern. Yes, ನೋಡ್ತೀನಿ. Next.
Fresh matter for admission.
Huh.
For the stay of order dated 3/11/22.
Yes.
Fresh matter, madam. RFA matter. And for the trial court matter, for injection matter. Which have been dismissed, madam. Building demolition mercy ಬರ್ತಾರೆ.
Have you paid any interim order?
Yes, madam.
ಅದನ್ನ ಹೇಳಿ first. Yes. Witness day.
One matter.
ಅದೆಲ್ಲದು ಆಫೀಸ್ ಸಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಆದ್ರೆ ಮಾತ್ರ.
The suit is for ejectment. 3 weeks of interim order was granted. The interim order will expire today. Just may have tomorrow. Kindly have it tomorrow.
At least 2 days ಮುಂಚೆ ಮೂವ್ ಮಾಡ್ಬೇಕ್ರಿ.
Lordship, it's admission stage, Lordship. So the appellant had filed a declaring suit in the trial court, Your Lordship. But it was dismissed, Your Lordship. Now the appellant has finished at the 10th standard, Your Lordship, and now she's trying to apply for her PUC, Your Lordship. In case, so that's the urgency, Your Lordship. If we don't get the name change order through the court, it will affect it.
Have you prayed for any interim relief here? Are there any IAS pending?
No, Your Lordship.
Then what is the urgency here?
Your Lordship.
What stage the matter is?
Admission, Your Lordship.
Admission. So by mere admitting, what relief you get there in the trial court?
No, Your Lordship, because the suit was dismissed, Your Lordship, there. Now, since the appellant has finished at 10th standard, she intends to change her name, Your Lordship. Now, if she has to apply in her PUC, the name should, the TC and every other official documents won't reflect the new name, Your Lordship. Hence the urgency.
Yes.
My lord, serial number 74, my lord.
Yes, mentioning from left side. Yes, proceed please.
Memo for withdrawal.
Serial number?
74.
Huh.
We are already filed declaration for cause of action.
Yes.
Declaration. So
Now what do you want?
filing memo for withdrawal.
File that memo when the matter reaches. Don't be so hurry. Yes.
It is 57, madam.
Yes.
1 week. Gotcha. It's 7.
First of the learned counsel for the appellant. A week's time as spread is granted as finally. Yes.
Leave, my lord.
62.
Yes.
It's for admission.
Yes.
Place for 1 week time.
Whom you appear for?
Appellate.
Same order. 1 week finally. Yes. Call the cases.
Your lordship, leave, my lord.
Second time. Number 1. What can see it?
I appear for the appellant, my lord. The is on record, my lord. I have not filed the memo for the withdrawal.
You have?
I have not filed any memo for withdrawal of the appeal, my lord.
Not filed.
Not filed. One Bhagyamma without obtaining the
Advocate
memo.
Mukul, sir.
File the.
YCH. YCH.
Have you given NOC to her?
No, my lord. Without NOC ವಕಾಲತ್ they have filed the ವಕಾಲತ್.
Signature thoroughly ಗೊತ್ತಿರೋದು paper ಅಲ್ಲಿ. Your good name?
ಹರ್ಷ ಕುಮಾರ್ ಗೌಡ. my lord.
Sir, counsel. Ashok Kumar Gupta. Who alone is physically present submits that he continues to represent the appellant and appear for him in this appeal. And that he has not given no objection wakalat to anybody, including the learned counsel, Miss Bhagya CH. He further submits that he has not filed any memo seeking withdrawal of the appeal and nor even instructed by the appellant for the withdrawal of the appeal. Next line. The registry has shown that one to be Bhagya CH along with one Sri Rajesh GS also have filed wakala for the appellant subsequent on 7/1/2023. However, the said wakala is without no objection from the previous counsel, that is Sri Harsha Kumar Gowda. In the view of the matter, the memo dated 7/2/2023 filed by the latest counsel Srimati Bhagya CH seeking withdrawal of the appeal cannot be proceeded with without hearing said counsel Srimati Bhagya CH and Rajesh GS have remained absent. The matter 28. 6. Yes.
Stage number 2. On complaints of office objection for that time. Kashina JD.
Rejected. Rejected.
Applied for the certified copies of the trial court's records, my lords. I have filed the NOC wakalat in last occasion, last month, my lords. I have applied for the trial court records. Still, I have collected.
The last occasion you made the very same submission, and as finally the time was granted. You are repeating the same submission, which is not fair.
Records.
Last time also a short time stating that you have filed no objection wakalat recently. Yes. And time was granted to you. The office objection inter alia includes like marking of annexures to be removed, typed copy of the trial court valuation slip to be filed, certified copy of the decree to be filed, list of document filed at page 16 and page 14 to be removed, para numbers in appeal memorandum to be correctly stated. For this, you filing the wakalat latest would not come in your way. 150 rupees per day cost. ₹1,050. It becomes 150 into 7. Yes. The learned counsel for the appellant, while reiterating the submission that she has filed no objection wakalat recently, successively prays for some more time to comply of his objection. On the previous dates of hearing also, the similar submission was made to the learned counsel. A perusal of the office objection which are due for complaints go to show that the inter alia includes very minor and trivial office objections which could have been attended within few minutes. As such, granting of any time would be only at cost at the rate of ₹150 per day. The said cost, the learned counsel for the appellant admits and prays for 1 week time. As such, imposing a cost of rupees 1,050 payable by the appellant to the Legal Services Committee of this court within 3 days from today and filing. However, at the rate of however, the cost is rupees 500 payable to LSC within 2 days from today and filing, etc., as an ultimate opportunity, 1 week. If not complied, list the matter and move to or on which day the court may proceed to pass appropriate order, etc. Yes.
Serial number 3, Sri Lokesh SG.
Let the author. After completing this matter, the office has stated that the value of the subject game is more than 50 lakhs. Therefore, second set has right.
Be 10-7. Yes.
Sri Devendrappa, for Devendrappa Rahman.
One of the subjection was that the date of institution of the suit in the decree as well as in the copy of the judgment differs, my lordships. So I have given a submission that there is a difference in the date of the judgment and then the decree, my lordships. The judgment, it is mentioned as 24/11/2014, my lordships. And then in the decree, it is mentioned as 22/11, date of institution of the suit. December 39.
Get a decree corrected.
I get the decree correctly, my lordships. Service standing.
You are granted sufficient time already, including on payment of costs.
Get it correctly, my lordships.
So for the very same purpose, you were already been granted sufficient time, even by imposing costs. Once again, you come up with the same reason, same extreme.
All the other of the subjections, my lordships. I get the.
That's
decree.
not the answer.
I'll get the decree.
The office subjections inter alia included the present pending office subjection also. To comply the same, you are granted sufficient time. On one occasion, a cost of rupees 500 was also imposed upon you. And as finally the time was granted, despite that you did not comply this said office subjection. On the other hand, you come up with the same reasoning. After hearing you, you are directed to comply the same.
I'll get the decree corrected, my lordships. So weeks time I can't be granted, my lord.
At what cost then? You fix the rate of the cost per day.
I'll get it corrected. my lordships.
No, already cost was imposed upon you on the previous occasion. You did not make any attempt in that regard. You kept quiet. Once again, the matter came up. You make the same submission. Yes, learned counsel for the appellant. Is physically present, heard her submission. Peruse the written submission submitted by the learned registrar judicial. Since the decree is to be drawn based upon the details shown in the judgment, and Admittedly, there is a discrepancy about the date of institution between the judgment and decree. It is for the appellant to get the judgment or the decree corrected wherever the alleged mistake with respect to the date of institution is said to have been crept in. Enabling the appellant to comply the same, sufficient and several opportunities have already been granted, including granting of further time by imposing a cost of rupees 500 on the previous date of hearing. Despite the same, the appellant has not attended to the said office objection and is once again praying for time. In that view of the matter, though the appeal could have been dismissed for non-compliance of office objection, however, considering the request made, imposing a cost of rupees 1,000 payable by the appellant to the Legal Services Committee of this court within 4 days from today and filing a compliance form, etc., etc. As an ultimate chance, 10 days time is granted to comply office objection. In case if the office objections are not complied in their entirety within the time, registry to list this matter on 5/7 on each day, the court may proceed to pause. So and so. Yes, sir.
Number 5, Sri Balkrishna M.R. Nagaraj N for gave it a respondent.
Present respondent, my lord. Suit for ejectment has been filed, my lord. I have taken the possession as per the decree.
Format. The counsel for the appellant or clerk counsel for the case alone is appeared to video conference. 4 times, if not complied, absent, no reasons forthcoming. 5/6, observation of the court. Cost not paid. Reason for non-prosecution, non-complaint, amount of LSC to be recovered, etc. Yes.
Here number 6, the S.A. Sudhikar.
Because all office objections are complied, except that court fee. The court fee issue itself is under challenge. It's a suit for partition, 200 rupees is already being paid. Now, the trial court, in its order dated, the order is the plaintiffs are liable to pay the court fee under section 35(1) of the Karnataka Court Fee Act, Suit Valuation Act on the market value of the social property. This order itself is in challenge before this honorable court. For that reason, I cannot comply the office objections because office objections is under challenge before this honorable court. It's a suit for partition. Para number 11, page 8. Specifically, one of the ground I have raised it. Further clearly heard that the plaintiff has to pay the court fee on the basis of market value under section 35, not under section 35 of the Suit Valuation Act. The trial court failed to appreciate that the suit for the partition court fee has to be calculated on the basis of the allegations made in the plaint. Though the appellant had categorically stated in the plaint that they are in joint possession of the scheduled property, but the trial court, while answering the issues wrongly, came to the conclusion that the plaintiff has paid to their joint possession over the scheduled property and directed the appellants to pay requisite court fee according to section 35 of the Karnataka Court Fee and Suit Valuation Act. It is submitted that the findings recorded by the trial court on the payment of the court fee.
2 options for you.
Please,
1, pay the court fee, and in case if you succeed, get the same refund date.
please.
or there is a reported judgment on the point, find it out and place it before me.
Yes,
3 days time.
Monday. Coming.
The land counsel for the offense submits that with respect to his non-liability to pay. The alleged deficit court fee, since the very alleged deficiency in the payment of the court fee itself is challenged. He has got a reported judgment to be placed before the court for which this accommodation. An ultimate opportunity, a week's time has paid is granted, failing which the court may proceed. Yes, list the matter on 28.
Are you?
Bill number 7, C. M.A. George, Prema NT for Cavitar R2.
Objections are complied with, except the valuations.
On cost. Double the cost what I did impose on the previous occasion per day. Last occasion, higher cost was suggested. However, the court reduced the cost and imposed a very, very nominal cost. Despite that, he have not complied the office objection. Therefore, 2 options: dismissal for non-compliance or cost which shall be higher than the previous cost, and that too on per day basis. Your submission that except the valuation, you have complied all other office objection is not correct. Yes, please. ₹100 per day. How many days you want cost? 1 minute. In spite of imposing cost and granting time spread for by the learned counsel for the appellant on the previous date of hearing, still he has not completed the office objection. Their entirety. There for some more time to complete. The suggestion of the court that the granting of further time would be on that the cost is accepted by the learned counsel. The price for a week's time, accordingly imposing a cost of ₹500 payable by the appellant to the legal services committee of this court within 2 days and filing a complaint memo, etc. Time as an ultimate opportunity, 1 week. As grade is granted, filing which the court may. In case the office objections are not complied in total, registry to list this matter on. Move on to our. Yes.
Serial number 8, C.
Office objection pending. Certified copy of board's valuation statement. We have already filed the same, which is at page number 49 as well as 53, my lord. Certified copy of the valuation slip in the original suit is already filed. It's at page number 49 as well as 53, my lord.
Why did you not make that submission on the previous date of hearing that it has already been filed.
On the previous date of hearing, we had not filed.
When did you file that?
Previous date of hearing, there were 4 office objections. Pursuant to that, we have complied with all 4 objections.
Previous date of hearing was 8/6/2023.
Yes.
According to you, the present 4 office objections were all raised subsequent to 8/6/2023.
No, it was already raised on 8/6/2023.
Then that is the reason these office objections were already there on the previous date of hearing. You did not comply the same.
Lord, we had not received the certified copy from the counsel who is appearing in the.
That is your problem.
My senior had made the same submission before this honorable court in the previous date of hearing.
That is your problem. Then it would be a very fit case to dismiss for non-compliance and also for non-prosecution because the appellant is not interested in prosecuting the appeal. Appellants are not cooperating means they are not interested in prosecuting the appeal. You are wasting the time by keeping quiet.
Already complied with every office objection.
Yes. Learned counsel for the appellant submits that he has already complied every office objection except producing the.
It's already complied.
He submits that he has already complied all office objections. A perusal of the order sheet would go to show that still 4 office objections are yet to be complied by him. Which office objections were in existence?
The submission.
Were in existence even prior to the previous date of hearing. That is on February 2022. Thereafter, 2 more days of hearing came on, which days also those office objections were invoked and shown as not complied. This go to show that the submission of the 11th counsel for the appellant that all the office objections are already complied is not correct. Hence, the appeal stands dismissed. Several substantive opportunities of not less than 4 times have already been granted.
Not the website. shows
Hence,
only one.
the appeal stands dismissed for non-compliance of office objection. Office objection includes so small office objection like the age of the appellant to be mentioned.
Lord, I have corrected that. All objections have
Oh,
been-
and ask the registrar as to why they are showing it as not complied despite you alleged to have complained.
My lord, the website shows only one office objection.
That is not my concern. You should fight it with the registry or the chief justice. 100 times, 1000 times I have told, even requested even the chief justice also, that several of the systems and working pattern of the registry are putting the learned counsels to inconvenience. Nobody heeds to my submissions. I have told your president Vivek Reddy 100 times, including day before yesterday. Instead of doing other work, say attend to the grievances of the learned counsels which they face in the registry. Nothing. What I shall do?
Serial number 9, Shri M.K. Shivaram.
None appear for the appellant. perusal of the note put up by the registry go to show that one of the office objection raised earlier is yet to be complied. However, the registry has raised a few more office objections on IA 1/23. Hence, as an ultimate opportunity, 1 week time is granted for the appellant to comply all the office objections, failing which the court may proceed to pass so. The learned registrar judicial to instruct the consent officials in the consent branch to avoid as far as possible the raising of subsequent office objections at a later date, though they could have been raised at the earliest point of time and thus causing inconvenience to the litigants and their counsels. The learned registrar judicial to submit the written report of complaints within a week from today. List the matter on 3/7. Yes.
Bill number 10, Sri Kapil Dixit.
Record copy valuation of them. It's to be received. Kindly.
On cost at ₹100 per day. The learned counsel for the appellant who has been granted several and sufficient opportunities, including as final opportunity, ultimate opportunity, is once again praying for time to comply with this objection. As such as a final ultimate opportunity, a week's time is granted. However, imposing a cost of ₹500 payable by the appellant to the legal services committee of this court within 2 days from today and filing complaints, etc. etc. In case if office objections are not complied in total, within the time registry to list this matter on move or on which day the court may. Yes.
Bill number 11, Prithvi Odier, Shri Prithvi Odier.
Get valuation is there. The time of the valuation is not filled before the time. But the objection was raised.
Then the appeal would stand dismissed for non-compliance of office objection. What submission you had made was already made on 12/6/2023. And accepting the submission made by the learned registrar judicial, you had prayed for time to comply with the office objection, imposing the cost. You are granted a time as prayed for complaints. Now, already a matter which was already over about the filing or non-filing of the valuation itself, you are now repeating the same submission.
I applied for the counterclaim of the cash and before the trial court. The matter as another appeal is pending and sent to LCR before this conduct. But I have later I have applied for it.
It's a council.
Another 2 days.
Last time also you prayed for 2 days. The court granted you more time.
Please, not I instructed to appellant to apply for the counterclaim copy before the trial court. That he has went and applied, but the trial court has said that another appeal was filed and it is called for LCR before this conduct. Therefore, they are sent file before this.
Submission was made on the previous day.
Submission. I applied for another 2 days that I will. Is not a file note that is not available and they counterclaim in the original file also. 2 days time allowed, I verify and I will.
Counterclaim was filed by you.
Please, ma'am. Before trial
Therefore,
court.
you are expected to know whether you have filed it or not.
Office copy is available, my lord, certificate copies are applied, but that is not in the.
So in office copy, the valuation slip is available. Available.
Available.
Then your submission that you have not filed the valuation slip in the counterclaim is incorrect.
Valuation, counterclaim fail, madam. Valuation is not filed before the trial court. That therefore I have.
Then how to assess the valuation of the counterclaim?
That in the property was included in the counterclaim, not in the one property was as claimed in the front end and the property, that was assessed, my lord, we have filed a counter valuation slip. This certificate.
Registrar report.
16 June 2023.
According to you, the subject matter property of the counterclaim was already a suit schedule property.
In my return counterclaim.
In your counterclaim, what property you have mentioned
Please,
was one among the suit schedule property.
please, my lord, that has dismissed. Counterclaim has dismissed.
On the previous day, you accepted the written submission of the learned registrar judicial, who has observed that in the decree there are no particulars about the said item number 1 of written statement schedule property, and there is no mention of its valuation or the court fee paid by the defendant. So what property you are mentioning in the written statement doesn't find place in the suit schedule property. It is specific observation. And the previous dates of hearing, the learned counsel for the appellant who is physically present in the court, accepting the reasoning shown by the learned registrar judicial for sustaining the office objections raised by the registry, prays for 1 more week's accommodation to comply the office objections in toto.
That I have made submission, my lord, in the last occasion, not in the. That there is no counter valuation slip is filed before the trial court. Therefore, I undertake to file a counterclaim certificate copy of the counterclaim, not valuations. Submission and return submission and before the earlier occasion.
The learned counsel for the appellant who is physically present submitted that prayed for 2 more days time, stating that the copy has been applied for. As such, it may require another 2 days to obtain the same. Later, he also made a submission that the defendant who filed the counterclaim has not filed the valuation slip because the written statement property was one among the suit schedule properties. The court brought to his notice the report submitted by the learned registrar judicial on the previous date, which was considered on the previous date of hearing, wherein the learned registrar judicial has categorically specifically stated that in the decree there are no particulars about the item number 1 of written statement schedule property, and there is no mention of its valuation or the court fee paid by the defendant number 2, bracket only present appellant, in respect of the said counterclaim. Next line, as observed in the order dated 12/6/2023, it is accepting the said report submitted by the learned registrar judicial. The appellant had sought for 1 more week time, as such, imposing a cost of ₹500 payable by the appellant, as a final last chance, a week's time as paid was granted. In spite of the same, the appellant has not complied and the office objection and is coming up with the submission that the written statement property was one among the suitable properties which, as analyzed above, appears to be not correct. In that view of the matter, when the appellant is not interested in complying the office objection, it has to be inferred that he is not interested in prosecuting the matter. As such, the appeal stands dismissed for non-compliance of office objection and for not. Yes.
Say number 12, say Bipin Hegde.
Payment of court is not, I have got the DD today. I will, receive the DD and wait in the office. As regards the second office objection, Lord, the office has raised that the certified copy of the execution proceedings have to be filed. Lord, I have produced the certified copy of the agreement of sale. What happened, Lord, this is the case where the ASFC filed a miscellaneous application against guarantors. That suit came to be decreed. Thereafter, Lord, I sought to attach a property and bring it for sale. At that point of time, one of the third respondent, he files an application under order 21 through 89 and 97 saying that I have got interest in this property, it belongs to me, therefore you cannot sell this property. That application, inquiry goes on, that application came to be allowed, against which, my lord, I have filed the appeal. It's a first appeal. Now, my lord, in the agreement of sale, he says that he agreed to purchase the property for 10,65,000. My lord, accordingly, my lord, I have valued it at 10,65,000. I am paying court fees of 65,125. ED is ready. I will pay it in the office. As regards the second office objection, my lord, that has to be overruled. Because the valuation in this case will be the objector's valuation. That agreement of sale also I have produced. The lords may kindly turn to page 24.
What is the second office objection?
Second office objection is the certified copy of the execution has to be filed under that is the office objection raised for the purposes of valuation. That cannot be the case because literally the agreement of sale under which the third respondent has filed this objector application has been allowed. Therefore, the valuation will be the sale consideration amount in the agreement of sale. That I have produced, my lord, kindly turn to in page 24. The sale price of the scheduled property is 10,60,000.
What is submission of the counsel for the appellant who has made his submission about the non-filing of the document of execution for the purpose of assessing the value of the appeal. On the similar lines of the report submitted by the learned registrar judicial. In view of the same, the office objection serial number 2 about the non-filing of certified copy of the document of execution stands overruled. With respect to the payment of court fee, the counsel for the appellant submits that the needful has been done.
Allah, it will be done. ED is ready. I will pay it.
ಮಾಡಿ ಬನ್ನಿ ಆಮೇಲೆ ಪಾಸ್ ಓವರ್ ಮಾಡಿರ್ತೇನೆ ಕಾಂಪ್ಲೇನ್ಸ್ ಮೆಮೋ ಹಾಕಿ ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ದೇನೆ. ಕಂಟಿನ್ಯೂ.
Seal number 13, Sri S. Ramamurthy.
For the appellant, my lord. Three objections are there, my lord. Court fee, I believe 75 rupees has been paid, my lord, for both the reliefs. Injunction suit, 25 rupees had been paid, and counterclaim relief was 50 rupees. 75 rupees seems to have been filed, given, my lord. As far as first objection is concerned. The lordship is hearing.
Two options. One is dismissal of the appeal for non-compliance of office objection. Another is granting a week's time imposing a cost of rupees 1,000. Which one you prefer?
Your whatever order your lordship may kindly pass.
Yes. Or the submission of learned counsel for the appellant who is appearing through video conference. A perusal of the order sheet would go to show that all the four office objections which are raised by the registry
Three are remaining, my lord.
of time are still open and yet to be complied with.
Last
Several of them
Saturday, one.
are very trivial and simple office objections like mentioning the dates and events in a chronological order, colon, correctly stating the pagination in the main index, requirement of acceptance of wakalat by all the counsels shown therein, which hardly requires 2 minutes to complete. However, in spite of granting sufficient adjournments of not less than 4 times, the appellant has not complied with the office objection. As though the appeal could have been dismissed for non-compliance of office objection, however, imposing a cost of rupees 1,000 payable by the appellant to the legal services committee of this court within 1 week from today and filing a compliance memo along with a seat, etc., in the set time as a final last opportunity. As an ultimate opportunity, 10 days time is granted to comply all office objections. In case if the office objections in toto are not complied within the said time after claiming the cost, the registry to list the matter on 4/7 on which the court may proceed to pass. So, yes.
Shri S. Ramurthy,
The same, my lord. In this case also that all the advocates have not signed ಅಂತ ಇದೆ. ಅವನ್ನೆಲ್ಲ delete ಮಾಡ್ಬಿಡ್ತೀನಿ ಸ್ವಾಮಿ. ಅವ್ರನ್ನೆಲ್ಲ ನಾನು ಒಬ್ಬನೇ ಇರೋ ಹಂಗೆ ಮಾಡ್ಕೊತೀನಿ. ಅದೊಂದು. Fresh page will be inserted, deleting those other names, my lord. ಅವತ್ತಿಗೆ 4/7 ಗೆ ಅಪ್ಪಣೆ ಆದ್ರೆ ಅವತ್ತು ರೆಡಿ ಇದೆ, ಅದನ್ನ ಆಗ್ಲಿಲ್ಲ ಹಾಕೋದಿಕ್ಕೆ ಅದನ್ನ.
The office objection which are required to be complied with, which are only 2 in number, hardly
Yes.
requires
Just
3 to 4
everything
minutes.
is ready, my lord, but unfortunately my junior could not attend. That is problem. I actually
My
sorry.
unfortunate thing is that repeatedly I am granting adjournment here.
Um,
And I am laboring my 14 staff to list this matter to record no progress in the matter.
I regret, my lord.
So one person
Sorry.
suffering inconvenience and my 14 staff suffering inconvenience. The inconvenience is more on this side.
I do realize, my lord. Sorry.
Yes.
I'll see that it is done next time. 4/7 अपने आपको दावत.
At the request of the learned counsel for the appellant, a final ultimate opportunity, 3 days, 4 days time is granted to comply office objection failing with so and so, so and so. In case if the office objections are not complied within the time registry to list this matter on 28, 6 on which day? Yes,
Date ಯಾವ್ದು ಅಪ್ಲೈ ಆಗಿದೆ?
28, 6.
Number
Yes.
15, Sri Harish Kumar MS.
Production of certificate copy of the valuation. From the. Rent.
Heard the submission of Learned Counsel for the appellant who is physically present on IA 1/23 filed under section so to seeking extension of the time granted on 13/6/2023 by 2 weeks for complying office objection number 2. Here is the memorandum of facts filed along with the application. Perusal of the order sheet would go to show that several and sufficient opportunities given as final and ultimate opportunity were all given to the appellant to comply office objection, despite which he has not complied with the office objection in their entirety. However, considering the reasons shown in the IA under consideration, I am of the view that truth, which time may be granted to comply, however, the same on terms. Accordingly, imposing a cost of ₹600 payable by the appellant to the Legal Services Committee of this court within 4 days from today and filing a compliance memo within the said time as an ultimate opportunity. 10 days time is granted as a final ultimate opportunity. 10 days time is granted to comply all office objections which are due for complaints, filing which the court would proceed to pass appropriate order, including so and so. If office objections are not paid after payment of cost, Registry to list this matter on 5/7. Yes,
Non-compliance of office objection 5th time.
accordingly, IA
Till number
1/23 stands partly allowed. Yes.
till number 16. Sri
Mar
Bharat
appellant.
Kumar B.
Appellant in this matter. So my senior 10 days in the Usharla, so my office ko bandirilla. Kindly give us 1 week, so please, my lord. 1 week ashte, so we'll clear all of its objections.
150 rupees per day.
Sir, 1 week, so.
The counsel for the appellant appearing through video conference once again prays for time. Considering the number of opportunities granted to comply office objection in this appeal of the year 2020, which are not less than 5 times, and also the nature of the office objection, which are to be complied. The court suggested to the learned counsel that granting of time would be only on cost at the rate of ₹150 per day, the learned counsel opt for 1 week's accommodation, hence imposing a cost of ₹1,050 payable by the appellant to the Legal Services Committee of this court within 4 days from today. Mundin the for ultimate opportunity, 1 week time is granted to comply. If not complied within the time, Registry to list this matter on 3/7 on which day the court may proceed.
Much obliged.
Okay. Dates to be stated in chronological order, para number to be given in order in appeal memorandum, blank to be filled in para number 2, 4 and 5. Senior ಬರಬೇಕು ನಿಮಗೆ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. ಇದು ದುರಂತ.
Sorry, my lord. ಈ ಸತಿ ಕ್ಲಿಯರ್ ಮಾಡ್ತೀವಿ.
Till number 17. Samarth, yes.
The panel belongs. My lord, second set must be filed, my lord. Office objection, which is regards to valuation paras remaining, my lord. The calculation by me was
And seven.
incorrect, my lord.
Yes.
Till number 18. Mohammed Basiruddin.
None appear. The office has shown that the office objection raised by it were subsequent to the previous set of office objections, comma, as an ultimate opportunity. Each time is granted to the appellant to comply the same. If not complete, list the matter on 28. Sit.
Yes, seal number 19, Sri Sitmalappa PM.
Paper appellant.
For the submission of learned counsel for the appellant. The delayed filing of the guidance value is accepted, registry to proceed further. The other office objection CPN still open for due for complaints are not complied. In a week from today, the registry, the court will proceed to pass appropriate order. In case office objections are still not complied in their entirety, list this matter on 4/7. Yes, sir.
Seal number 20, Udrappa P.
All office objection complied. Yes. Can the court pass a peremptory order then? If the office objections are still open, the appeal would stand automatically dismissed on its own.
Complete all the submission.
Further submission of learned counsel for the appellant. Delayed payment of cost is accepted. Learned counsel for the appellant submits that all office objections are complied by him. A perusal of the proceeding sheet submitted by the registry go to show that the registry has noticed till 8 office objections are due for complaints which were raised at the earlier by the registry.
I'll check it in the office. I'll check it in the office.
Registry. When the court brought the same to the notice of the learned counsel for the appellant, the learned counsel for the appellant still submits that he has complied with the office objection in toto. Asks registry to verify whether the 8 office objections which are now shown open as on date are complied. If they have complied, but still the registry has shown them as not complied, then the learned registrar judicial to submit his written explanation after issuing the memos to the concerned officials. If those office objections truly exist for complaints, then the submission made by the learned counsel, despite the caution given by the court about the pendency of the office objection, compels this court to pass a peremptory order accordingly. In case if those office objections are still due for complaints, the appeal on its own stands dismissed for non-compliance of office objection without any further posting before the court and without any further order by this court, but with effect from 4th.
Number 21, Sri Victor Manoharan, head
Applicant, my lords. Lords, in respect of first objection, my lords, that is, in the OS document as on the date of filing of the suit, I have produced partition deed, my lords, exhibit P6. They have sought any OS document as on the date of filing of the suit, my lords. In respect of that, my lords, I have produced partition deed dated 18/11/77.
1 minute. Yes, that alleged partition deed is several years prior to the date of institution of the original suit, right? Therefore, as on the date of filing of the suit, what was the valuation of the property is required to ascertain the jurisdiction. So the partition deed would not be of any help to in that direction.
Because that's the document which has been produced, my lords, at the time of filing of the original suit.
Sir, you have approached the court.
Please.
You were the plaintiff in the trial court. Therefore, it was for you to place before the court the relevant details, including the documents regarding the valuation.
Please.
For having not done an act which you were supposed to do, you cannot now keep quiet or shift the burden on others. You cannot say wash your hand by telling that no, that is what we have filed. In hundreds of matters, every day I come across tens of matters. Your counterpart in the trial court who are required to take a minimum care, they won't take. In the appeal, you try to patch up the same by making several submissions, but in some occasions, some may be accepted, but not in all cases at all times. There ought to be some record before the court to ascertain the jurisdiction.
Please, I'll find out and then.
You are already been granted with a lot of time, several times, granting some more time on the same preaching.
No, I was under the impression, my lords, because based on this only, my lords, we had.
Sir,
filed this
your impression is nothing to do for complaints of office objection. You may have several impressions, but what is acceptable is the point. I myself have given you the sufficient time in this matter.
Please.
It's not for the first time that it's coming before me now. It has come before me on earlier few vacations also. To do the same exercise, sufficient time I myself has granted to you.
The second objection, my lords, the death certificate what I have produced, my lords, shows us Shantabai, whereas in the
That we will accept.
and the as regarding third objection, my lords, I have filed IA.
You have filed IA,
Just to
fine.
check, my lords, in respect of this first objection.
Yes, that is important.
2 days time, my lords,
On cost. I don't think within 2 days you can do anything. 200 rupees per day, I will grant you time.
a week's time.
1,400 rupees would be the cost.
Please.
In view of the, heard the submission of learned counsel for the appellant about the office objections. In the light of the submission made by the learned counsel for the appellant, which have already been recorded by the registry in the order sheet, objection number 2 and 3 about the alleged discrepancy in the name of Srimati Shanti and filing application to bring legal representatives of deceased defendant number 1 stands overruled. With respect to office objection at serial number 1, since the learned counsel for the appellant once again prays for time and concedes that he is required to file the certified copy of the document or proof before the trial court, showing the valuation of the suit properties as on the date of filing the original suit. Ain't under sentence act survive.
Since the learned counsel for the appellant once again pays for time and concedes that
And sufficient time have already been granted of not less than 6 times. Our final ultimate opportunity, a week's time is granted, imposing a cost of ₹1,000 payable by the appellant to the Legal Services Committee of this court within 4 days from today and filing a complaints memo, etc., etc. In case if cost is not paid and office objections are not complete within the set time, registry to list this matter on 3/7 on which day the court may proceed to pass it.
Complaints of office objection for 6th time, serial number 22. P. Rangaswamy,
Appear for appellant, my lord. With regard to court fee is concerned, my lord. Kindly peruse page number 56. The valuation filed by the plaintiff itself is wrong, my lord.
Yes, please.
The valuation of the total social property is rupees 48 lakh, my lord.
Valuation of the
Total value of the property, my lord.
total value of the property. Can you read the valuation slip filed in the original suit, please?
Page number 56, my lord.
Yes, please.
The suit filed by for partition separate position of the plaintiff half share in the plain scheduled properties. The market value of the share of the plaintiff is more than 48 lakhs as they are joint in joint position.
Therefore, your submission that the total value of the social property is 48 lakh rupees is incorrect, right?
Yes, yes, my lord.
Then why did you make such incorrect submission?
I am the fourth defendant in the.
So you made a submission that the valuation of the suit schedule property is 48 lakh rupee.
It is mentioned by the plaintiff, my lord. But according to the
No,
defendant.
what the plaintiff has mentioned, you read it just now.
Yes, yes, my lord.
Read it again for yourself. Read it again for yourself, that one sentence in the second paragraph.
The market value of the
market
share
value
of the
of the share of the plaintiff,
is more than 48
not the
lakhs.
total value of the property.
Yes, yes, my lord.
Share of the plaintiff itself is more than 48 lakh rupee, not the total value.
Yes, my lord.
You
But in the
submitted
last
that the total value of the property is 48 lakh rupee.
But it is wrongly mentioned by the plaintiff, my lord.
How should I accept that? You did not contest that, you proceeded in the trial court accepting the said valuation. It is an evaluation made by the plaintiff, accepted by the court, not denied or disputed by the defendant. Merely here through video conference, we say that it is not properly done. Do I have to accept that?
In the last paragraph, the
Matter
value
is
of,
very simple. Accepting the same, we can proceed with, because it doesn't alter the liability of payment of any additional court fee for which you are not prepared.
yes, my lord, I will pay the necessary court fee.
ವ್ಯರ್ಥ ಪ್ರಯತ್ನ ಅಂತಾರೆ ನೋಡಿ, ಅರ್ಥವಿಲ್ಲದ ವ್ಯರ್ಥ ಪ್ರಯತ್ನ.
Sorry, my lord.
Further submission of learned counsel for the appellant peruse the written submission submitted by the learned registrar judiciary. When the very valuation slip filed by the plaintiff in the trial court, the certified copies of which are at page number 56 and 57 of the memorandum of appeal clearly and categorically mentions that the market value of the denoted comma share of the plaintiff close denoted comma is more than 48 lakh rupees. It is not known how come. Both the learned counsel for the appellant and the learned registrar judicial has taken it as the market value of the total of the property and confined it to rupees 13,71,429 as the share of the as the market value towards the share of the alleged share of the plaintiff. Hence, the report of the learned registrar judicial is not acceptable. So also the submission made with the learned counsel for the appellant. Learned counsel for the appellant prays for 4 days time to comply the office objection. Considering the fact that several and sufficient opportunities of not less than 6 times have already been granted to him,
1 week, my lord. 1
granting
week.
of further time would be only on cost. Accordingly, imposing a cost of rupees 500 payable by the appellant to the Legal Services Committee of this court within 4 days from today and filing a complaint memo, etc., as an ultimate opportunity. 1 week time is granted to comply. In case if after objection or complaint, list the matter on 5/7 on each day. Yes.
First matter, seal number 23, Sri Vardarajan MS, SCGP for R1 to R4.
Appellant has taken back and was in that. Take back papers. Big memo.
Respondents.
The counsel for the appellant and SCGP for R1 to R4 are physically present. There is a memo of retirement filed by the legal counsel for the appellant who has stated that appellant has taken back all the case papers along with the NOC, engage another counsel as such. He has paid for his retirement from appearing for the appellant in this appeal. The appellant was called out. Who is he? Who is physically present in the court and is duly identified by the legal counsel for the appellant. ಏನ್ ಹೇಳ್ತೀರಿ ನಿಮ್ಮ ವಕೀಲರು? ನಾನು ಈ ಕೇಸಿಂದ ರಿಟೈರ್ ಆಗ್ತಿದ್ದೀನಿ, ನೀವು ಕೇಸಿನೆಲ್ಲ ವಾಪಸ್ ತಗೊಂಡಿದ್ದೀರಿ, ಕೇಸ್ ಪೇಪರ್ಗಳು, ಅವ್ರು ಇನ್ನು ನಿಮ್ಗೆ ಅಪಿಯರ್ ಆಗಲ್ಲ, ನೀವು ಬೇರೆ ವಕೀಲರನ್ನ ನೋಡ್ಕೊಳ್ತೀರಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಏನ್ ಹೇಳ್ತೀರಿ? ಬೇರೆ ಆಲ್ಟರ್ನೇಟ್ ಮಾಡಿದ್ರೆ ವಜಾ ಆಗುತ್ತೆ ಕೇಸು. ಒಂದು ವಾರ ಟೈಮ್ ಕೊಡ್ತೀನಿ, ಬೇರೆ ವಕೀಲರನ್ನ ತಯಾರು ಮಾಡಿ ಕರ್ಕೊಂಡ್ ಬರ್ಬೇಕು. ಅವ್ರು ಮಾಡ್ಕೊಳ್ಳೋದಾದ್ರೆ ಮಾಡ್ಬೇಕಿತ್ತು. ಅವ್ರಿಗೆ ಬರವಣಿಗೆಯಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ನಾನು ಈ ಕೇಸಲ್ಲಿ ರಿಟೈರ್ ಆಗ್ತಾ ಇದ್ದೀನಿ, ನಾನು ಕಂಟಿನ್ಯೂ ಆಗಲ್ಲ ಅಂತ. ಅದು ನೀವುಂಟು ಅವ್ರುಂಟು, ಅವ್ರು ಒಪ್ಪಕೊಳ್ಳಿಕ್ಕೆ ತಯಾರಿಲ್ಲ, ಬರವಣಿಗೆಯಲ್ಲಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ನೀವು ರಿಟೈರ್ ಆದ್ರ ಮೇಲೆ ಏನ್ರಿ ಅವ್ರು ನಮ್ಮ ಇದ್ ಮಾಡ್ತಿದ್ದೀರಿ? ಅದು ಅವ್ರಿಗೆ ಬಿಟ್ಟಿದ್ದಲ್ವೇ, ಕೋರ್ಟ್ ಇದೆ, ನಾವೇ ಅವರಿದ್ದಾರೆ. Appellant Madan Gopal submits that he would request the present counsel appearing for him to continue in this matter and prays to keep the memo of retirement in abeyance for a period of 1 week. Further submits that in case the present counsel for the appellant is not acceptable, then he would engage the services of another counsel within the said time. Next time, making it clear to the appellant that the appeal is of the year 2017. This is one of the old appeal and hence no further adjournment to be granted. Among a week's time as grade is granted. This is the matter on 3/7. 3ನೇ ತಾರೀಕು ಕೇಸ್ ಬರ್ತದೆ. ಅಷ್ಟರೊಳಗೆ ಇವರನ್ನೇ ಮುಂದುವರಿಸ್ತಿರೋ ಅಥವಾ ಬೇರೆ ವಕೀಲರನ್ನ ನೇಮಿಸ್ಕೊಳ್ತಿರೋ ತೀರ್ಮಾನ ಮಾಡಿ, ಬೇರೆ ವಕೀಲರನ್ನ ನೀವೇನಾದ್ರೂ ನೇಮಕ ಮಾಡ್ಕೊಳ್ಳೋದಾದ್ರೆ ಬೇರೆ ವಕೀಲರಿಗೆ ವಕಾಲತ್ ಕೊಟ್ಟು ಅವ್ರ ಹತ್ರ ವಕಾಲತ್ ಹಾಕ್ಸಿ ಅವ್ರನ್ನ ಕೋರ್ಟಿಗೆ ಕರ್ಕೊಂಬರ್ಬೇಕು. 3ನೇ ತಾರೀಕು ಸೋಮವಾರ ಬೆಳಗ್ಗೆ ನೀವು ಇರ್ಬೇಕು, ಆ ವಕೀಲರು ಇರ್ಬೇಕು. ಇಲ್ದ ಹೋದ್ರೆ ಕೇಸ್ ವಜಾ ಆಗುತ್ತೆ. Yes.
Seal number 24, C Prakash, M. Bharti for Caveator R1 along with connected matter.
Paper.
Papers of the learned counsel for the appellant. 2 weeks time is granted to file paper.
ಕಾಮನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಒಂದರೊಳಗೆ ಹಾಕಿದ್ರೆ
ಅದಾದ್ಮೇಲೆ ಫಸ್ಟ್ ನೀವು ಹಾಕಿ ಆಮೇಲೆ ಅದೆಷ್ಟರಲ್ಲಿ ನೋಡ್ರಿ.
Seal number 25.
I'm appealing for the appellant, my lord. I pray for some time, my lord.
The RB Sadashivappa for R1 to R3.
I'm appealing for the appellant, my lord. I pray for some time, my lord.
Rejected.
I'll take steps and I'll find out the correct address, my lord.
You should have done that by this time.
Earlier, I taken steps, my lord, but address that service.
You should
is
have
not-
followed the same with the registry.
I will do it, my lord. Kindly accommodate.
You have
my-
not done it for the past 6 years. 6 years.
2-3 times I've taken steps, my lord. Earlier advocate has taken steps, my lord. Recently I
Yes, 3
Vakalat, my
times
lord.
steps have been taken. Therefore, you are quite aware that with the set address, the notice is not being served, and you should have put your effort in ascertaining the correct, complete, and present address and taken steps. You had
I will
6
do it.
years
I will
time
do it, my lord. Kindly accommodate 2 weeks, my lord.
on cost, 200 rupees per day. The counsel for the appellant appearing through video conference. Praise for time, giving no reasons. When the court told him that without any reasons, the adjournment would not be granted, the learned counsel stated that he is yet to ascertain the address of the unserved respondent number 4 and 5. Next line, perusal of the order sheet would go to show that 3 times the notice has been sent to those respondents, which from the first attempt itself is being returned as addressee left and no such person in that address. Despite the same, the appellant has not evinced any interest in ascertaining the correct, complete, and present address of unserved respondent number 4 and 5 and to take appropriate steps. Appeal is of the year 2017 and still is at the stage of the service of notice upon the respondent. After bringing the same to the notice of the court, after bringing the same to the notice of the learned counsel for the appellant, when the courts suggested that granting of further time would be only on cost at the rate of rupees 150 per day, the learned counsel doesn't react in any manner. Hence, it is inferred that the appellant is not interested in taking the steps as against unserved respondent number 4
I will
and
take steps, my lord. I will take steps.
the appeal as against respondent number 4 and 5 stands dismissed for not taking step. In
I will
view
take
of
steps, my lord.
the dismissal of the appeal as against respondent number 4 and 5, the maintainability of the appeal as against the remaining respondent is also required to be.
I request you, as well, kindly grant
Thank you.
1 minute time, my lord. I will do it, my lord. I will do it, my lord.
List this matter on 6. Yes.
Seal number 26, see Sachin PS, see Rohit Goda for R1,
For the applicant, my lord. Filed a memo. Respond number 2 to.
along with connected matters.
In the meantime, the appellant to file the paper book in the. Yes. Yes, please.
Filed a dispensation memo, my lord. Is an expert in the trial court, my lord. 2 to 19 and 27 and 8, my lord.
I appear for the appellant in this case, my lord. What more? I am I audible, my lord?
It's audible.
In this case, all contesting respondents have been served.
I have already a counsel in this matter who is on his legs and making his submission. You can see that on the screen. Still you are intervening. 29 ಅಲ್ವಾ 30
ಮೂವತ್ಮೂರು ನೀನ 33
33
ಮತ್ತೆ ನಿನ್ ಮಾತು ಕೇಳ್ಕೊಂಡು ನಾನು ಹೇಳ್ದಾಗ
Heard the submission of learned counsel for the appellant on the memo dated 7/7/2018 seeking dispensation of notice to respondents number 2 to 19, 27 and 28. It is stated in the memo as well in the submission of learned counsel for the appellant that those respondents who were the defendants in the trial court were placed ex parte. In the light of the memo supporting submission made by the learned counsel for the appellant, notice to respondents number 2 to 19, 27 and 28 are dispensed with, however, the consequence and risk of the appellant. Yes,
29 also served. First matter 29 served. The second similar matter second served. 29 also first matter served.
ಅದಕ್ಕೆ
Second matter same similar matter.
ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್ ನಲ್ಲಿ ಎಷ್ಟು ಅವ್ರದ್ದು ಸೀರಿಯಲ್ ನಂಬರ್
29.
ಅವ್ರಿಗೆ ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಿದ್ದಾರೆ
ಇಲ್ಲ ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಿಲ್ಲ ಸರ್.
ಮತ್ತೆ ನೀವು ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಬೇಕಲ್ವೇ? ತಗೊಳ್ಳಿಲ್ಲ.
ತಗೊಂಡಿದ್ದೀನಿ ಬಟ್ ಅದು ಸರ್ವ್ ಆಗಿಲ್ಲ ಮತ್ತೆ ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್.
For several other respondents, you are yet to take steps. Why don't I dismiss the appeal as against those respondents against whom we have not taken steps?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎಕ್ಸ್ಪರ್ಟ್ ಆಗಿದ್ದಾರೆ.
ಟ್ರಯಲ್ ಕೋರ್ಟಿನ ಎಕ್ಸ್ಪರ್ಟ್ ಏನ ಈಗ ನಾನು ಇಲ್ಲಿ ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಿದ್ನಲ್ರಿ, ಎಕ್ಸ್ಪರ್ಟ್ ಆಗದೆ ಇರೋರದ್ದು ಅಥವಾ ನೀವು ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಕೇಳದೆ ಇರೋರದ್ದು
ಅದನ್ನ ಸ್ಟೆಪ್ಸ್ ತಗೋತೀನಿ.
ಎಷ್ಟು ವರ್ಷಗಳು ಬೇಕಿನ್ನು ಹೇಳಿ? ದಿವಸಕ್ಕೆ 50 ರೂಪಾಯಿ,
2 days ಅಂತ
2 days ಅಲ್ಲಿ ತಗೊಳ್ತೀರಿ, 100 ರೂಪಾಯಿ ಕಾಸ್ಟ್. With respect to the other respondents, with respect to whom the appellant has not been taken steps, the appellant is granted 2 days time as paid, however, imposing a cost of ₹100 payable by the appellant in each matter to the Legal Services Committee of this court during the course of the day and filing a complaints memo within the said time before the registry. In case if the steps are not taken within the time of the paying the cost, registry to list this matter on 26/6, on which day the court may proceed to pass appropriate order, including dismissal of the appeal as against those unserved respondents for not taking steps. Yes.
Serial number 27. Say M. Veerabhadraya. Say DS multi-party for R1 to R4.
I paid the paper book on 17/8/2017 itself.
The counsel for the appellant submits that he has paid paper book on
17/8/2017.
17/8/2017. However, the registry is still showing that the paper book is not filed. Learned registrar judicial to make his submission in that regard. Yes, what about the other aspects?
I mean, in a adversary, the weak time. Otherwise, I think in an application.
3 days time is granted to the appellant to take fresh steps to ensure the service of notice upon the unserved respondents. In case if the appropriate steps are not taken, reach this matter on 27/6 on which day? Yes.
Vaishali Hegde, Vai Hari Prasad for Kevita respondent.
This matter. All respondent.
One minute. 1 minute, please. I have sent a copy of this memo to other side. You have the acknowledgement.
We have not received.
Yes, please.
We have not received the copy.
You copy ಬಂದಿಲ್ಲ ಅಂತಾರೆ ರಿಜಿಸ್ಟರ್ ಪೋಸ್ಟಲ್ ನೀವು ಕಳಿಸಿರೋದಕ್ಕೆ ಏನ್ ಹಾಕ್ಬೇಕು ಹೇಳಿ ನೀವು ಕಳಿಸಿದಕ್ಕೆ ತೋರಿಸದ ಅವ್ರು ತನಗೆ ತಲುಪಿಲ್ಲ ಅಂತ ಹೇಳ್ತಿದ್ದಾರಲ್ಲ ಅದಕ್ಕೆ ನೀವು ಅವ್ರಿಗೆ ತಲುಪಿದೆ ಅನ್ಲಿಕ್ಕೆ ಏನ್ ತೋರಿಸ್ಬೇಕು ಮತ್ತೆ ಅಲ್ವೇ ಪಾಸ್ ಓವರ್ ಮಾಡಿರ್ತೇನೆ ತಗೊಂಬನ್ನಿ ಅವರಿಗೆ ಕಾಪಿ ಕೊಡಿ Learned counsel from both sides present. Learned counsel for the appellant submits that the copy of the memo dated 29/3/2022 has not been furnished to the appellant. Assess the appellant. Furnished to the appellant. Learned counsel for the respondent. Those submits that he has sent the said copy of the memo to the appellant, however, admittedly has not produced any acknowledgement in that regard. Hence, the learned counsel for the appellant is directed to furnish a copy of the memo. If forthwith kodi, ಆಮೇಲೆ ನಿಮ್ಮ ವಾಪಸ್ ಇಸ್ಕೊಳ್ಳುವಂತಿರ ಅದರದೊಂದು ಕಾಪಿನ. Hence, the learned counsel for the respondent has furnished a copy of the said memo along with annexures to the learned counsel for the appellant. Yes.
I kindly asked it to it's the list of the LRs, my lord.
That is between you. We need not. Yes. Then, do you want any details? Say the typing of the LR application and it's being given to you. Then at least while making the submission before the court, don't carry it away by your seniors who, due to their practice, take some liberty with the court. The juniors shouldn't. The counsel for the appellant prays for a week's time to file LR application.
ಇದೇನೋ ಇದು
Time as prayed is granted. Mute ಮಾಡಿ ಅವ್ರನ್ನ. Yes, next.
ಈಗ 29 ನಡೆದಿದ್ಯಾ
Yes.
Seal number 29, CA Madhusudan Rao. Vijay Prakash BR for Kevetar R5 and R7.
And the LR application. LR respond number 1. Office of the date.
Date ಸಿಕ್ಕಿದೆ ನೀವು ಹಾಗೆ ಹೇಳಲಿಕ್ಕೆ ಆಗಲ್ಲ. Learned counsel for the appellant prays for 2 days time to comply office objection raised on IA 1/22. Two days of 4 days. The time as prayed is granted. In the meantime, the appellant to file paper book. Yes.
Case number 30, C.S. Kalyan Basuraj.
In R4, the legal representatives are the remaining respondents R1, 2, and 3. I have filed this appeal arising out of the judgment and decree of the trial court where I was not a party. Partition suit was filed by the daughters against the father, and suit was decreed. And during the FTB proceedings, I came to know about it, and I have eventually challenged it before this honorable court. There are a bunch of about 24 appeals which have been filed, these 3 respondents are the legal representatives of the deceased R4.
That probably you know, court won't know.
If my lord, steps forward, going to avoid but I thought I'll just bring it to the notice of the lordship. I'll take steps further.
Then can we dismiss the matter for the time being then?
There are a bunch. I will take steps during the course of the day, my lord.
ಮತ್ತೆ ನೀವೇನು ಕೋರ್ಟ್ ಉಪಕಾರ ಮಾಡೋ ರೀತಿ ಸಬ್ಮಿಟ್ ಮಾಡ್ತೀರಲ್ರಿ ನೀವು ಮಾಡ್ಬೇಕಾಗಿದ್ದು ಮಾಡಿಸ್ಬಿಟ್ಟು ಏನೋ ಕೋರ್ಟಿಗೆ ಒಂದು ಸಹಾಯ ಮಾಡ್ತಿದೀವೇನೋ ಅನ್ನೋ ಟೋನ್ ನಲ್ಲಿ ಆ ಸ್ಟೈಲ್ ನಲ್ಲಿ I can take the steps. Otherwise, I thought that the court would consider. ಇವೆಲ್ಲವೂ ಏನಾಗ್ತದೆ ನೀವೆಲ್ಲರೂ ಕೆಲವರು ದೊಡ್ಡದವರು 50 ವರ್ಷ 60 ವರ್ಷ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಆಗಿ ಮಾಡಿರೋರು ಮಾಡೋ ಕೆಲವು ಸ್ಟೈಲಿಶ್ ಸಬ್ಮಿಷನ್ಸ್ ಗಳು ನೋಡ್ಕೊಂಡಿರ್ತೀರಿ. ದಟ್ ಈಸ್ ದ ಸಬ್ಮಿಷನ್ ಅನ್ನಂಗ್ ಹೋಗ್ತೀರಿ ನೀವು. ಪ್ರಾಬ್ಲಮ್ ಇರೋದು ಅದು ಈಗಿನ ಯಂಗ್ಸ್ಟರ್ಸ್ ಅಲ್ಲಿ ಈಗಿನ ಜನರೇಷನ್ ಅಲ್ಲಿ.
ಕ್ಷಮೆ ಇರಲಿ, ನಾನು ಆತರ ದಟ್ ವಾಸ್ ನೆವರ್ ಮೈ ಇಂಟೆನ್ಷನ್. ನಾನು ಏನ್ ಹೇಳಿದ್ರೆ
ಇಂಟೆನ್ಷನ್ ಇರಲ್ಲ, ಆದ್ರೆ ನೀವು ಗೊತ್ತಿಲ್ಲದೆ ಅದನ್ನ ಫಾಲೋ ಮಾಡ್ತಿರ್ತೀರಿ.
I apologize, my lord. I will ensure I won't do such submissions as well. ನಾನು ಹೇಳಿದ್ದು because these are the daughters.
ಉಳಿದವರು ಯಾರು ಆಲ್ರೆಡಿ ದೇರ್ ಆರ್ ದಿ ಲೀಗಲ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಇದ್ದೀರಿ, ಅದನ್ನ ಕೋರ್ಟ್ ಗಮನಕ್ಕೆ ತರಲಿಕ್ಕೆ ಒಂದು ನಮೂನೆ ಇದೆ, ಒಂದು ವಿಧ ಇದೆ. ಅದೊಂದು ಓರಲಿ ಹೇಳಿ ಅಥವಾ ಮೆಮೊ ಹಾಕಿ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. ಅಷ್ಟೇ ಸರಳವಾದ ಇನ್ನೊಂದು ಉಪಾಯ ಇದೆ. ಅದನ್ನು ಮಾಡಿದಾಗ ನೀವು ನಿಮ್ಮ ಮೇಲೆ ಯಾವುದೇ ಹೊರೆಯನ್ನು ಹೊರಿಸಿಕೊಳ್ಳದೆಯೇ ಕಾನೂನಾತ್ಮಕವಾಗಿ ಅದನ್ನ ಕಡತದ ಮೇಲೆ ತರಬಹುದು. ನಾಳೆ ಅದರಲ್ಲಿ ಏನೋ ಹೆಚ್ಚು ಕಡಿಮೆ ಆದ್ರೂ ಕೂಡ ವಕೀಲರ ವೈಯಕ್ತಿಕ ಜವಾಬ್ದಾರಿ ಇರುವುದಿಲ್ಲ. ಅದನ್ನು ಮಾಡಿ. At the request of the learned counsel for the appellant, a week time is granted. Yes.
There are about other 24 appeals. Ella connect agide. Maybe call along with RFA 868 of 2017.
ನನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಾಡೋದು ನೀಡ್ಫುಲ್ ಮಾಡ್ರಿ, ಆಮೇಲೆ ಯಾರ ಜೊತೆ ಕಳಿಸ್ಬೇಕು ಕಳ್ಸೋಣ.
ಯಾಕಂದ್ರೆ ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಹೇಳಿದ್ದಾರೆ. ಸೊ ಮತ್ತೆ ಒಂದೊಂದು
ನೋಡೋಣ. ಇದ್ರಲ್ಲಿ ಫಸ್ಟ್ ಸತ್ತೋರ್ ಪರವಾಗಿ ಉಳಿದವ್ರನ್ನ ಯಾರು ತರಬೇಕು ತನ್ನಿ, ಆಮೇಲೆ ಉಳ್ದಿರೋದ್ ಮಾಡುವ. ಏನ್ ತಗೊಂಡ್ರಿ? Granted to do needful with respect to alleged deceased respondent number 4. Yes.
I appearing for the appellant, my lord. 3 weeks time, my lord. I filed a paper book, my.
On cost.
My lord. 2 weeks, my lord.
4 years.
I filed.
4 years back, I myself had granted you time on more than one occasion. 4 years back. You are again trying for time.
Only 2 weeks, my lord. I filed.
500 rupees per week.
My lord.
I can grant you
only
up to 6 weeks time at the same rate. No discount.
Only 2 weeks, my lord. I'll be filed, my lord. 2 weeks time.
Learned counsel for the appellant appearing through video conference, who initially prayed for 3 more weeks time to file the paper book, reduced it to 2 weeks after hearing from the court that the granting of further time would be only and cost at the rate of rupees 100 and at the rate of rupees 500 per week. Several and sufficient opportunities have already been granted to the appellant to file paper book as long back as in the year 2019, including an opportunity as finally, despite which the appellant has not evinced interest to file paper. In the light of the above, imposing a cost of rupees 1,000 payable by the appellant to the Legal Services Committee of this court within a week from today and filing a complaint from etc. etc. As an ultimate opportunity, 2 weeks time as spread is granted to file paper book. failing which the court would proceed to pass appropriate order, including dismissal of the appeal for non-filing of paper book. In case if cost is not paid and paper book is not filed within the time as above, the registry to list this matter on 12/7. Yes.
Case number 32, HM Harsha, CT CH-8 for Kevita respondent.
The sole respondent. 53/2020 passed away. I have found the death certificate. It's a suit for rejection. It will be dismissed. Corporation does not show.
Even today also, the learned counsel for the appellant is neither present physically nor through video conference. Counsel for the K-waiter of the respondent alone is present and reiterates his submission that as submitted in his memo dated 29/5/2023, the sole respondent is dead and the cause of action does not survive as against the legal representatives of the deceased respondent. Thus, the appeal is to be dismissed. Next line. The respondent has filed a memo dated 29/5/2023 reporting the death of sole respondent, who is said to be dead on 15/3/2020. A death certificate is also produced along with the memo. The appellant was granted opportunity to file objections, if any, to the said memo, even as finally also. In spite of the same, the appellant has not filed their objection, if any, to the said memo. Next line. The contention taken up in the memo that sole respondent died on 15/3/2020 is corroborated by the death certificate produced along with the memo. Undisputedly, the present appeal is an appeal by the plaintiffs in the trial court who have challenged the dismissal of the suit for a bare injunction. According to learned counsel for the respondent, cause of action doesn't survive in the matter due to the death of the sole respondent. The appellant has not shown about the continuity of the cause of action against the legal representative of the deceased respondent. In view of the same, holding that due to the death of the sole respondent, the suit for permanent injunction and the fact that the plaintiffs who have lost their suit on merit or the appellants before hearing, the appeal stands dismissed as due to the death of the sole respondent, the cause of action doesn't survive for the appellant to continue as one of their legal representatives.
Number 33.
I appear for the appellant.
Ramesh Kumar for Kevita R1.
Lord, I am sorry that I disturbed without knowing that my matter is being called.
Not just disturbing, you are talking to your clerk also continuously and interfering in. ಏನಪ್ಪ ಇದು ಯಾಕೆ ಹಿಂಗಿದೆ ಅಂತೆಲ್ಲ.
I'm very sorry, my lord.
No, at least you should take care that say when you are talking to others loudly, you should mute your microphone there.
Yes.
Yes, proceed please.
My lord, in this, The contesting respondents have been served. And I will see that the wakalat is being filed for respondent 6 to 8.
There are few more respondents yet to be served, right?
I'll see that, my lord, respondents 1 to 4, 3 is no more, and respondents 1, 2, and 4 are the contesting respondents.
Respondent 3 is no more, is not known to the court and to the registry.
That I'll file the memo. I'll file the memo and her LRs are already on record. Your lordship may grant me 3 days time.
Then why did you move this matter despite knowing that
Despite
there are
knowing I
few
did
more
not know all
respondents
these
who are yet to be
objections.
served?
I did not know all these objections. When the matter is being posted, I came to know all this. That I'll see to that all these are complied with.
The learned counsel for the appellant who is appearing through video conference. I got this matter listed by moving a memo. Some of the respondents are still not served and the office has raised objection on IA 1/23, stating that the said IA is premature since the other respondents are not served yet. Despite the same, since the appellant has got this matter listed and now praying for a time to do needful in the matter, the court is imposing a cost of rupees 300 upon the appellant for not properly utilizing the precious time of the court. The said cost is liable to be paid by the appellant to the Legal Services Committee of this court within a week from today and to file a complaints memo along with original receipt to that effect in the registry within the said time. Yes.
Seal number 24, Shri Kiran CV.
Here for the appellant, your lordship. That delay happened because I had to obtain the valuation slip from the trial court, your lordship.
For the submission of learned counsel for the appellant, the eligible delayed payment of cost is accepted, registry to process further.
Seal number 35, Shri Devendrapa.
Money matter nallu delay. So this is the third matter with the delay you are reporting. That is the procedure habit in your office that has to be changed.
No, the problem is valuation, lower court is the valuation, third party.
ಇದೆಲ್ಲ ಹೇಳ್ತಿದ್ದೀರಿ ನಾನು ಇದು ಮೂರನೇ ಮ್ಯಾಟ್ರ್ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೇನೆ ಅಂತ ಅಲ್ವೇ ನೋಡಿ ನಾನು ಎಲ್ಲ ಪ್ರತಿಯೊಬ್ರು ವಕೀಲರದ್ದು ಕೋರ್ಟ್ ಸೈಜ್ ಇಂದ ಹಿಡಿದು ಅವರದ್ದು ಕೇಸ್ ಸೈಜ್ ವರೆಗೆ ಎಲ್ಲದೂ ನೆನ್ಪಿಟ್ಕೊಳ್ಬೇಕು. ಎಸ್ ಹೋಗಿ.
Number 35, Shri Devendrapa, Pawan Kumar appeal for Capital R1.
Further submission of learned counsel for the appellant, delayed payment of cost is accepted, registry to process.
Number 36, Prakash Committee, Shri Narayan TH for R4.
Learned counsel for the appellant submits needful done registry to verify and proceed further. Interim order granted earlier is extended by 2 weeks from today.
Serial number 37, Rachana, Srimati Rachana Bharadwaj, Vinod Kumar BN for Kevetar R2.
More than 15 lakhs.
EB 11/7.
Number 38. C.A. Kumar Vel.
Make the submission at 2:30 p.m. No, make the submission at 2:30 p.m. Juniors must be thorough and clear in their submission. Yes, yes. Yes. Ah.
Stop the value.
11.7 dB. Yes.
Seal number 39. See Sanat Kumar Shetty K.
Same order. 11.7 dB.
Seal number 40.
Respond number 2 is to E. During the pendency of the appeal, respond number 2B has died on 11/1/2023.
Who died?
Respond number 2B to Sudhakar.
When he died?
11/1/2023.
Whether respondent to be has already been brought on record.
On record. It appears that he died January. He permitted to take steps.
Sudhakar, son of late P. Gopalakrishna Reddy. He is shown as respondent number 3 here, not respondent number 2B.
2B one.
He is shown as respondent number 3 in the memorandum of appeal.
Document which has been furnished to me here.
ಅದು ಮಾಡ್ತಾರೆ ಕೋರ್ಟಿಗೆ ಹಾಕಿದ್ರೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಬಂದಾಗ ಅದನ್ನೆಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತಾರೆ ಎದುರುಗಡೆ ವಕೀಲರುಗಳಿಗೆ ಹಿಂಗ್ ನೋಡ್ರಿ ಒಂದು ಚೇಂಜ್ ಮಾಡಿದೀನಿ ಅಂತ ಹೇಳಲ್ಲ. Probably Somashekar Reddy, who was supposed to be an exception, also has not done what the court can do.
Exactly, this honorable court has observed. It was office objections that was.
ಹೌದು ಅಂತದೇನಾರ ಇದ್ರೆ ಎದುರುಗಡೆ ಒಂದು ಫೋನ್ ಮಾಡಿ ಸ್ವಲ್ಪ ಬದಲಾವಣೆ ಮಾಡ್ಕೊಳ್ರಪ್ಪ ಅಂತ ಹೇಳ್ಬೇಕು. Yes, he is respondent number 3 here now. When he died?
11/1/2023.
Learned counsel for the appellant and learned counsel whom you appear for.
Respond number 2A to 2E. That is the legal case of Gopalakrishna Reddy. Chinnamma, Sudhakara, Raghunatha, Girija, Kavita.
ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಿ?
That is filed on
ಒಂದು ನಿಮಿಷ ಇರಿ.
2/1/2018 only. January 2nd.
ಮಹೇಶ್ ಸಿಎಂ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 to 6 ಅಂತ ತೋರಿಸಿದ್ದಾರೆ. ನೀವು ಅಲ್ಲಿ ಚೇಂಜ್ ಮಾಡ್ಕೊಳ್ಳಿ, ನೀವು ಚೇಂಜ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂದ್ರು ನೀವು ಇನ್ನೂ ಮಾಡ್ಕೊಳ್ಳಿಲ್ಲ. ಅದು ಸರಿ, ಸೊ ಅದನ್ನ ಮಾಡಿ. Learned counsel for respondent number 2 to 6 who is physically present submits that respondent number 3 Sudhakar died on
11/1/2023.
11/1/2023. ಅದಕ್ಕೆ ಏನಾದ್ರು ಮೆಮೊ ಗಿಮೋ ಹಾಕ್ತಿದ್ದೀರಿ?
Asked the death certificate.
ಈ ಫಸ್ಟ್ ಒಂದು ಮೆಮೊ ಹಾಕ್ಬೇಕಲ್ವ, ಅವ್ರು ನೋಟಿಸ್ ತಗೊಳ್ತಾ ಇರೋದನ್ನ. ಅವ್ರು ಒಂದು ಹಾಳೆ ಕೊಡ್ರಿ, ಆಮೇಲೆ ₹2 ರಿಜಿಸ್ಟ್ರಿ ಕಟ್ಟಿ ಪೇಪರ್ ಕಾಸ್ಟ್.
ನನ್ನ ಕಡೆನೇ ಇದೆ paper.
ಇಲ್ಲಿ ಹೊರತರ ಇದೆ ಅಂತ ಬಿಡಿದೆ, ಇದನ್ನ ತಗೊಳ್ಳಿ. ಎಸ್, ಅಷ್ಟು ಪೇಪರ್ಗಳನ್ನು ಮಡಚಿ ಇಟ್ಕೊಳ್ಬೇಡಿ. ಲಾಯರ್ ಕೋರ್ಟ್ಗಳಲ್ಲಿ ಜೇಬ್ಗಳು ತೆಗಿಬೇಕಿಲ್ಲ. ಬರೀ ಮೊಬೈಲ್ ಸಾಕಲ್ಲ, ಈಗ ಪೇಟಿಎಂ ಗೂಗಲ್ ಪೇ ಇರ್ತದೆ. ಏನ್ ತಗೊಂಡ್ರಿ? ಕೌನ್ಸಿಲ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 to 6 files a memo reporting the death of respondent number 3 on so and so date. Learned counsel for the appellant I praise for time to take appropriate step, praise for 2 weeks time to take steps in that regard. 2 weeks time as spread is granted. Yes.
Seal number 41. See Arun L. C. Narayanaswamy, correspondent.
Counsel for appellant not present, counsel for respondent alone present. List this matter. On 27/6. Yes.
Number 42. See, P. Mahesha.
It's made clear that no further adjournment will be granted in the matter. Yes.
Bill number 42. C. P. Mahesha.
The appellate. Suppose R3A and R3B are served. Proposed R3A and R3B are served in this matter. Lordship may consider my IA 4 of 21, 5 of 21, and 6 of 21. And with respect to unserved respondent R5.
ಒಂದು ಬಂಡಿ ಇದೆ ಇಷ್ಟುದ್ದ.
ಅದೇ with respect to other unserved respondent.
ಈಗ ಯಾವ್ದು ಕನ್ಸಿಡರ್ ಮಾಡಬೇಕು?
IA 4, 5, and 6 of 2021.
That is with respect to what?
And with respect to bringing LRs of R, this is R3 on record.
This is the R3 and record. Whether the other respondents have no say on those IAs, they had. Therefore, all other respondents are also required to be served.
Very well, Manoj.
Alway, ಮತ್ತೆ ಯಾವಾಗ ತಗೊಳ್ತೀರಿ ಸ್ಟೆಪ್ಸ್?
Well, it's 2 weeks time may be granted.
ಸಾಧ್ಯ ಇಲ್ಲ.
Well, in this.
ಒಂದು ವಾರ ಕೊಡಬಲ್ಲೆ ಬಟ್ ಆನ್ ಕಾಸ್ಟ್.
Well, this, it was listed on 9/2/2023. 1 week's time was granted, the very same day we have taken steps. It has the postal shara received by the court is insufficient address. I'll have to instruct my client to get the proper address.
ಇಲ್ರಿ ಇಬ್ರಲ್ಲಿ ಒಬ್ಬರಿಗೆ ಹೇಳ್ಬೇಕು ನಾವು. ಒಂದು ರಿಜಿಸ್ಟರ್ಗೆ ಹೇಳ್ಬೇಕು. ಕೆಲಸನ ಚುರುಕಾಗಿ ಮಾಡಿಯಪ್ಪ, ಬೇಗ ಮಾಡಿ, ಸರಿ ಮಾಡಿ. ಅವ್ರು ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಮ್ಗೆ ಸಿಗೋದು ವಕೀಲರಿಗೆ ಹೇಳ್ಬೇಕು. ಅಲ್ವೇ? ನೀವು ಸ್ಟೆಪ್ಸ್ ಕಟ್ಟಿದ್ರ ಮೇಲೆ ಕನ್ಸರ್ನ್ ಸೆಕ್ಷನ್ಗೆ ಹೋಗಿ ಅಯ್ಯ ಮಹಾರಾಯ ನಾನು ಸ್ಟೆಪ್ ಕಟ್ಟಿ 1 ತಿಂಗಳಾಯ್ತು, ಅದು ಏನಾಗಿದೆ, ಸರ್ವಾಗಿದೆ ಇಲ್ವೋ ನೋಡಿ ನೀನೊಂದು ಲಿಸ್ಟ್ ಮಾಡು, ಪೋಸ್ಟ್ ಮಾಡು ಅಂದ್ರೆ ಮಾಡ್ತಾರೆ. ಅದಕ್ಕೂ ಮೀರವ್ರು ನಾವು ಮಾಡಲ್ರಿ ಅಂತ ಹೇಳಿದ್ರೆ ಅಟ್ಲೀಸ್ಟ್ ಒಂದು ಮೆಮೋನಾದ್ರೂ ಮಾಡ್ಬೇಕು. ಸೊ ದಟ್ ಸಮ್ ಪ್ರೋಗ್ರೆಸ್ ಕ್ಯಾನ್ ಬಿ ಅಚೀವ್. 2017 ಮ್ಯಾಟರ್ 6 ವರ್ಷ ಆಗಿದೆ, ಇನ್ನೂ ಸ್ಟೆಪ್ಸ್ಗಳೇ ಆಗ್ಲಿಲ್ಲ. ಅಲ್ರಿ ನಾನು ಈಗ ಹೇಳ್ತಿರೋದ್ ಕೇಳಿ, ನೀವು 2 ಸರ್ತಿ ಅಲ್ಲ 20 ಸರ್ತಿ ಕಟ್ಟಿ ಅವ್ರು ಅದನ್ನ ಇಮಿಡಿಯೇಟ್ ಲಿಸ್ಟ್ ಮಾಡಬೇಕು. ನೀವು ಹೋಗಿ ಕೇಳ್ಬೇಕಂತಿಲ್ಲ, ಅವ್ರು ಲಿಸ್ಟ್ ಮಾಡಬೇಕು. ಪೋಸ್ಟಲ್ ಟ್ರ್ಯಾಕ್ ನಲ್ಲಿ ನೋಡಿ, ಅದು ಮುಂಚೆ ಅಕ್ನಾಲೇಜ್ಮೆಂಟ್ ಕಾಯ್ತಾ ಇದ್ರು, ಈಗ ಪೋಸ್ಟಲ್ ಅಕ್ನಾಲೇಜ್ಮೆಂಟ್ ಕಾಯುವ ಅವಶ್ಯಕತೆ ಇಲ್ಲ ಅವರಿಗೆ. ಫ್ರಮ್ ದ 15th day of dispatching the notice, it is the duty of the registry to see in the postal track and ascertain the delivery of the notice. It is their duty. Every day they have to do that. There is a circular in that regard upon the registry. ಹಾಗಾಗಿ ಅವ್ರು ಮಾಡ್ಲೇಬೇಕಾಗಿರೋದನ್ನ ಅವ್ರು ಮಾಡ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ, ಒಂದು ನೀವು ಅಲ್ಲಿ ಹೋಗಿ ಮಾಡಪ್ಪ ಅನ್ಬೇಕು. ಅದಕ್ಕೆ ಇಲ್ಲ ಅಂದ್ರೆ ಮೆಮೋ ಹಾಕಿದ್ರೆ we can take care of the same and see that say the service of notice should be completed at the earliest. ನೀವು ಮಾಡಲ್ಲ, ಅವ್ರಿದ್ದವ್ರು 3 ವರ್ಷ 4 ವರ್ಷ ಸ್ಟೆಪ್ಸ್ ತಗೊಂಡ್ರ ಮೇಲೆ ಅದನ್ನ ನೋಟಿಸ್ ನ ಕಳಿಸ್ಲಿಕ್ಕೆ 6 ತಿಂಗಳು 8 ತಿಂಗಳು 1 ವರ್ಷ ಮಾಡ್ತಾರೆ. ಅಥವಾ ನನ್ನಂತವ್ನು ಬಂದು ಅವರಿಗೆ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ತೇವೆ, ನೋಡಿ ಆಲ್ RFAs should be listed before me in this roster, no exception. ನಾನು ಅದನ್ನ ಪ್ರತಿ ಸರ್ತಿ ಮಾಡ್ತೇನೆ. ಯಾವುದೇ ರೋಸ್ಟರ್ ಹೋದ್ರು ಅದು ಕಂಪ್ಲೀಟ್ ಪೆಂಡಿಂಗ್ ಲಿಸ್ಟ್ ಕೇಸ್ ವೈಸ್ ತಗೊಂಡು ಇಂತಿಂತ ವರ್ಷದ್ದು ಇಂತಿಂತ ವಾರದಲ್ಲಿ ಪೋಸ್ಟ್ ಆಗ್ಲೇಬೇಕಂತ ಹೇಳಿ ಅದನ್ನ ಫಾಲೋ ಅಪ್ ಮಾಡ್ತೇನೆ. ನೀವು ಮಾಡ್ತೀರೋ ಇಲ್ವೋ, ನಿಮ್ಮ ಕೇಸು ಈ ನಂಬರ್ದು ಎಷ್ಟು ಸರ್ತಿ ಬಂದಿದೆ ಅನ್ನೋದನ್ನ ನಾನು ಲಿಸ್ಟ್ ಇಡ್ತೇನೆ. ಮೈ ಸೆಕ್ರೆಟರಿ ಇಸ್ ಡೂಯಿಂಗ್ ದಟ್. ಹಾಗಾಗಿ ನನಗೆ ಗೊತ್ತಾಗ್ತಿದೆ. ಎವರಿ alternate days I summon the pending branch. I ask them the reasons why these matters are not listed. ರಾತ್ರಿ 9:30 ಇರ್ತೇನೆ ನಾನು ಚೇಂಬರ್ ಅಲ್ಲಿ. ಮಾಡ್ಬೇಕಲ್ವೇ ಯಾರಾದ್ರೂ ಒಬ್ರು? ಇಲ್ದ ಹೋದ್ರೆ ಸಮನ್ಸ್ ನೋಟಿಸ್ಗಳು ಹೋಗ್ಲಿಕ್ಕೆ ಇಷ್ಟು ದಶಕಗಳ ಕಾಲ ತಗೊಂಡ್ರೆ ಯಾವ ಕಕ್ಷಿದಾರರು ನಿಮ್ಮ ಮೇಲೆ ನಮ್ಮ ಮೇಲೆ ನಂಬಿಕೆ ಇಡ್ತಾರೆ? The counsel for the appellant prays for a week's accommodation. to ascertain the correct, complete and present address of unserved respondents and to take steps. And also to take steps with respect to the deceased respondent number 7. Time as grade is granted.
Number 43. HM G Srinivasa for R1 and R3 to R8. G Uday Kumar for proposed R2 A to R2E.
Memo ಕೊಡಿ. Further submission of learned counsel for the appellant upon the memo dated 11/4/2022 filed by the appellant seeking. ಕೊಡಿ ಗೊತ್ತಿಲ್ರಿ. ಅಡ್ವೊಕೇಟ್ ಸಿಗ್ನೇಚರ್ ವಕಾಲತ್ತಲ್ಲಿ ಇಲ್ಲ. ಜೋರ್ ಮಾಡಿ ಹೇಳ್ಬೇಕು ನಿಮ್ಗೆ ನಾನು. ಮಾಡಿ.
Bye, sir.
Deleting respondent number 12/113. In view of the memo supporting submission. Respondent number 12/113 stands deleted from this memorandum of appeal, however, at the consequence and risk of the appellant. Appellant to carry out the necessary amendment in the first title of the memorandum of appeal within a week from today. Part 2 ಎಲ್ಲಾರು ನೋಟಿಸ್ ಹೋಗಿದೆಯಾ?
ಹೋಗಿಲ್ಲ.
ಹೇಗಿದೆ ಅದು ಯಾವ್ದ ಈ ಉದಯ್ ಕುಮಾರ್ ಕೌನ್ಸಿಲ್ ಕೂಗಿಸ್ರಿ.
G Uday Kumar for proposed R2 A to R2E.
ನಿಮಗೆ 2 ಕೋಟಿ ಸತ್ಯ ಹೇಳಿದ್ದೀನಿ, ಲಕ್ಷನೂ ಅಲ್ಲ. ಯಾವುದೇ ವಕೀಲರ ಹೆಸರು ಕೂಗಿಸ್ತಾ ಶ್ರೀ ಅಥವಾ ಶ್ರೀಮತಿ ಸೇರಿಸಿ ಕೂಗಿಸ್ರಿ.
Shri G Uday Kumar.
All other respondents are served.
Yes, my lords. All, sir.
ಯಾವ್ದು ಪೆಂಡಿಂಗ್ ಇದೆ? In spite of having sufficient time, the learned counsel for respondent number 2A to 2E, proposed respondent 2A to 2E has not filed objection beginning to a 2/17. Okay, there was the SEDA which is filed on the phone seeking to bring the legal representatives of Alizi BC, the respondent number 2 on record. The statement made in the affidavit accompanying the application that respondent number 2 died on 5/5/2017 is corroborated by the death certificate accompanying the application. The applicant has stated that the proposed response number 2A to 2E shown in the application or the legal representative of the deceased respondent number 2. Considering the nature of the suit and the appeal, the cause of action surveys against the appellant to sue, surveys for the appellant even against the proposed respondent number 2A to 2E. Hence, IA 2/17 stands allowed and the proposed respondents 2A to 2E are permitted to be brought on record as legal representatives of this is the respondent number 2. The appellant to carry out the necessary amendment as stated the memorandum of appeal and to file amended memorandum of appeal within 2 weeks from today in the registry. You may have to take notice upon those respondents afresh or to ensure that the present counsel undertakes to continue to appear for them. Better for you is to request Mr. Uday Kumar, the learned counsel, so that his submission would be recorded by this court. List the matter in the week after next. In the meantime, the appellant should carry out to file paper book. Munche list after 2 weeks. 2 weeks munche on sentence learned counsel for the appellant submits that. No fresh notice upon the respondents 2A to 2E be ordered on the main appeal, and that he would request the learned counsel appearing for them to continue to appear for those respondents, however, on the instructions from those respondents. How ನೆನಪಿರ್ತದೆ next day ಬಂದಾಗ ಇಲ್ಲಿ ಅವರದ್ ಮರ್ತು ಹಾಗೆ ಮುಂದೆ ಹೋಗ್ತಾರೆ. ಪೇ ಅಪ್ಲಿಕೇಶನ್ ಬರ್ಲಿ ಅವ್ರು ಬರ್ಲಿ.
I have the benefit of entry order.
ಎಂಟ್ರಿ ಮಾಡರ್ ಇವತ್ತಿನವರೆಗಿದ್ರೆ ನೋಡುವ. ಇಲ್ಲ ಯಾವಾಗ್ಲೂ ಮುಗಿದೋಗಿದೆ. ಇಲ್ಲಿ ಕೊಟ್ಟೇ ಇಲ್ಲ ನಿಮಗೆ ಎಂಟ್ರಿ ಮಾಡು. ಇಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ, ಅದಕ್ಕೆ ದಯೆಗೆ ಎದುರುಗಡೆ ವಕೀಲರು ಬರ್ಲಿ. ಈಗ ನೋಟಿಸ್ ಈಗ ಕಂಪ್ಲೇ ಆಗಿದೆ. The respondents to file their objections if any to other pending IAS within the said period. Yes.
Serial number 44, Sri Super Ready KN, Sri Jeevan K for Kevitar R1.
Who appears for R1? You have filed wakalat for 1A to D. You have no objection to allow those IAs? Counsel for the appellant and respondent proposed respondent number 1, R1A to D are physically present. The counsel for proposed R1A to D submits is no objection to allow IAs 2, 3, and 4 of 2017. But submission from both sides on those 3 IAs. ಮುಂದಿನೆಲ್ಲ ಫಾರ್ಮ್ಯಾಟ್ ಹಾಕಿ the counsel for proposed respondents 1A2. D submits that in view of he continuing to appear for those respondents, no fresh notice need to be ordered on respondents number 1A to 1D on the main appeal. The said submission is taken on record. Amendment ಮಾಡಿ amended memo of appeal ಹಾಕಿ ಅವರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡಿ 2 weeks maximum. Registry amended memo ಹಾಕಿ ಬರೀ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಅಲ್ಲ. Yes.
Seal number 45, Sri Ramu case, V. Papegowda for R1, V. Rahul for R2.
None of them. Hence the matter could not be proceeded.
Seal number 46, Sebastian Arvindiyam Neglur for R1 to R3.
Whom you appear for?
For this point, 1 to 3.
No objection to allow a delay. Heard their submission. On a 1/18 filed by the appellant under section so and so seeking condonation of delay of 40 days in filing the appeal. The counsels for the respondent submits there. No objection to allow this delay. In view of the reasons shown in the affidavit accompanying the application, and more importantly, the no objection submission made by the learned counsel for the respondents. 1/18 stands allowed and the delay of 40 days in filing the appeal stands.
Number 47 is application. Chandrina for David respondent. Connected
An application, seeking dispensation of the cable. The lower court records have summoned and here before this honorable court.
These are on the exhibits version of the office and Modi. Yeah, person. Let him summon the TCR. Let him check whether the original exhibits are there at 2:30 PM.
Say number 48. See B N
Learned
Umesh.
counsel from both sides present. Call the matter at 2:30 PM to enable the registry to secure the TCR in the matter. To enable the court officer to secure the TCR from the registry. Yes.
Say number 48. See B N Umesh.
Appellant. Yeah.
Equity. Is there any relationship between appellant number 1 and appellant number 2? Appellant number 1 and
The
appellant.
brother. Appellant number 2 husband's brother is appellant number 1.
For the submission of learned counsel for the appellant who is physically present on A number 1/23 and the affidavit. Dated 5/6/2023. Filed by appellant number 3. Respondent, since have been served but remained absent, have not filed their objection if any to the said IA and affidavit. Next line, both in the affidavit accompanying IA 1/23 and the separate affidavit dated 5/6/2023 filed by the appellant number 3, it is stated that appellant number 2 passed away on 18/10/2020. They have not produced death certificate. Produce death certificate. First, the learned counsel for the appellant present is granted a week's time to file death certificate of alleged deceased. Appellant number 2. A week's time as it is granted.
Number 49. Sri Venkatramana case.
Suit was for then why did you lose?
Here, the defendant's question is that there is survey number and the arrival of the genealogy of the property is different, whereas the plaintiff genealogy of the property is different. Fine. And the second point, the defendant has relied upon the partition suit between the plaintiff's family.
By the submission of the event counsel for the format has been notice mail and TCR. Yes.
Case number 50, Sri Prabhu Goda beach Mugi.
ಒಂದು 2 ತಿಂಗಳು ಬಿಟ್ಟಿದ್ರೆ 3 ವರ್ಷ ಕಂಪ್ಲೀಟ್ ಆಗೋದು ಕಂಡೋನೇಷನ್ ಆಫ್ ಡಿಲೆಗೆ ಅಲ್ವೇ? PCR ಹಾಕ್ಲಿಲ್ಲ ಚೆಕ್ ಬೌನ್ಸ್ ಅಕ್ವಿಟ್ ಆಯ್ತು. ಅದಾದ್ರ ಮೇಲೆ ಇಲ್ಲಿ ಬರ್ಲಿಕ್ಕೆ ಮನಸ್ಸು ಮಾಡಿದ್ರು. ಕೋರ್ಟ್ ಫೀ ಉಳಿಸುವ ನಮೂನೆಗಳು ಇದೆಲ್ಲ ಹೇಳ್ಕೊಡ್ತೀರಿ, ಕ್ಲೈಂಟ್ಗಳು ಮಾಡ್ತಾರೆ. ಈಗ ಅದೃಷ್ಟ ಕೆಟ್ಟ ಎದುರುಗಡೆ ಅವ್ರು ಬಂದು ಕಂಟೆಸ್ಟ್ ಮಾಡಿ ಸ್ವಾಮಿ ಅಲ್ಲಿ PCR ಹಾಕಿದ್ದಾರೆ, ಅಲ್ಲಿ ಅಟೆಂಪ್ಟ್ ಮಾಡಿ ಎಲ್ಲ ಗೊತ್ತಿದ್ದು ಅವರಿಗೆ ಕೇಸ್ ಹಾಕ್ಲಿಕ್ಕಿದೆ, ಸಿವಿಲ್ ಜ್ಯೂರಿಸ್ಡಿಕ್ಷನ್ ಹೋಗ್ಬೇಕು ಮನಿ ರಿಕವರಿಗೆ ಅಂತ ಗೊತ್ತಿದ್ದು ಇವ್ರು ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ತೀರಿ? ಇಷ್ಟೇ. ನೀವು ನಿಮ್ಮ ಕಕ್ಷಿದಾರರಿಗೆ ಒಂದು 100-200 ಸಾವಿರ ರೂಪಾಯಿ ಉಳಿಸ್ಲಿಕ್ಕೆ ಹೋಗಿ ಅವರ ಭವಿಷ್ಯನ ರಿಸ್ಕ್ ನಲ್ಲಿ ಬಿಡ್ತೀರಿ. ನೋಟಿಸ್ TCR.
Sri Ramesh case.
Participation as partly great number.
So not happy. You want the share in all the properties.
No, A schedule that have been denied. The B schedule.
ಅದೇ ಎಲ್ಲದೂ ಬೇಕು. ನೋಟಿಸ್ TCR. ತಗೊಳ್ಳಿ.
Case number 52, Sri Ravi HK.
Partition. Today's occasion mostly because after original suit got disposed of, RA was filed. Subsequently, it was realized that the jurisdiction lies before this honorable court. Therefore, an IA was filed seeking to appeal back and present it before this honorable.
Notice TCR.
53, Prakash Tipanna Hebbar.
Days are there.
Notice TCR.
Case number 54, Sri Vardarajan MS.
Suit was for
First declaration and possession, which is the defendant is the appellant. Chaser of the property from the other defendants.
notice TCR.
Case number 55, Sri Deshpande Amitanand.
Counsel for the appellant not present. The matter could not be proceeded.
Still number 56, Sri Prakash Tipurepar,
The suit was specific. Of 100 years.
Notice this here.
it is better. Still number 58, yes, Venkateswara Rao,
For declaration. This advertisement. The subsistence of the PDA was questioned. And board, taking into consideration that, relevant point of time I did not have. License issued by the PPA.
If you could request the standing counsel, if any, for the respondent number 1, I can pass over the matter and direct him to take notice if he present at 2:30 PM today.
Because BBMP also is there, 2 councils will have to be served.
BBMP is not a party here.
One is central government.
Probably if it were to be a case of the hoardings and fluxes, at a later stage, one of the party may take that contention that BBMP is not made a party.
However,
That we'll see later. For the time being, in the central government, if you request the central government standing council, either this afternoon or in the next week,
Speak, I'll serve the trial court council who represented there. So
they will be having their standing council here in
I
High Court.
understand.
It is Union of India.
Yes, same council. However,
The same councils you can, I will give a date, you can request him on that day. If you physically present, say, you will save a lot of time to send notice to them and somewhere it go and lie in some south block or north block or no block in New Delhi. All those things can be avoided. And you are required to serve an advance copy also to them.
I'll have.
In the meantime, you do that and obtain acknowledgement. Learned counsel for the appellant who is physically present submits that he will try to ensure the presence of the learned standing counsel for the respondent number 1, Union of India, on the next date of hearing. After having duly served him the copy of memo of appeal. So also we have ascertained that whether he appears for the respondent number 2 and 3 also. If that were to be the case, you can ensure that he accepts the notice for all the 3. Okay, after serving duly the copy of so and so. Yes, list the matter on 30 or 36.
PCRs could be secured. PCRs could be
Early
secured.
notice ಹೋಗಿ ತರಿಸುವ
Notice, sir.
ಜೊತೆಗೆ ಆರ್ಡರ್ ಮಾಡುವ. Yes.
number 59, Sri Ramakrishna M.
Such a matter be made. To be dismissed.
Why did you lose?
As I have failed to substantiate that there is an encroachment.
Hmm.
Though they have given a reason that I am the owner of the property. Even finding that they failed to prove the encroachment. There is no problem. Though I have produced a layout plan.
What is the reason given by the trial court in answering issue number 2 in the negative?
That's what, there is a no proper document regarding the encroachment and there is no survey sketch. Though I have produced a layout plan. There is no 63A. Schedule to be property.
For the submission of current counsel for the appellant. To the memorandum of appeal in this judgment. Issue emergent notice. Why don't you keep the BBMP council present this afternoon? They will be somewhere here. Now bring them, I will direct them to take notice. That will save you a lot of time. That is passed over to enable the counsel for the appellant to ensure the presence of the learned panel advocate for respondent number 1 and 2. Call the matter at 2:30 p.m.
Bill number 60. Sri Somshekhar DK.
Good for partition has been made. Like it is. That my mother had no title to the property and therefore I could not have gone for partition. At the same time, defendant number 3 and 4 purchased the very same property from defendant number 2 is my sister. And they also filed an appeal before this on 14 RA 1406 of 2020.
That is pending.
Yes, fine.
Counsel for the appellant submits that one more appeal bearing RFA number so and so filed by the parties here and is pending. For the same relief.
Their claim is rejected on the ground that
So the same relief of partition with respect to same property and place to list both the matters together. Registry to verify and do need. Yes.
CH-8 Subbarao.
Request any of the panel advocate of BBMP to be present in the afternoon, 2:30. They will be somewhere here. Large number of BBMP advocates are there who are on panel. We will direct him to accept notice. Matter is passed over, call at 2:30 p.m.
Bill number 63. HV Devraju.
What matter regarding furnishing of the correct valuation slip. OS number 6909/2011 for the purpose of jurisdiction. The valuation slip rule in page 127. Where that it is the first instance suit was filed in the court of the city senior division.
Office objection. Whether this office subsection was kept open for complaint.
Submitted submissions. That the way that valuation slip obtained certified copy from the trial court. Shown that a blood
That is your explanation. My question is.
Explanation blood that is the first instant.
My question is. Whether this office subsection, which according to registry is due for complaints, was on the main appeal or raised subsequently.
The
Main appeal. Then how come the matter was listed for admission without complaints of office subsection?
Connected case blood that is within a posted along with this blood that is the last cases in the matter.
We'll call for the TCR. Or the submission of land counsel for the appellant. In order to ascertain the correctness. Slip, a copy of the valuation slip at page 129, which shows the two original numbers. The trial court record. Be called accordingly, call for TCR in both RFA 31/2022 and RFA 10/2022. Yes.
Both is what similar suit, one suit, 6909 up to 2000. One suit, one appeal is filed, rejection of the count claim, another appeal suit decreed.
As such, call for TSR in RFA 10/2022. Yes.
Shrimati Sweta Anand, MS Venugopal for respondent.
Why you are unsuccessful in rejecting the tenant?
That I should have asked. The reasoning given by the,
So you could not able to prove tenancy.
yes, I could not, because I was on the transit. My client is from Mumbai, he was working there. So he got transferred and he could not find out certain documents. And what he had produced, and notice was ordered. So they remained absent and hence the rental agreement could not.
Or the submission of land counsel for the appellant who alone is present. Admit. Report 6 weeks. Yes.
Bill number 65. Sri Raghu Prakash Bamudi, Sri M. Ashwath Narayan Reddy.
Wait for a parcel. Before the parcel.
Other date. The junior counsel for the appellant is physically present. The counsel for K-8 is also physically present. List this matter in the week of the next as request.
Bill number 66. Sri Shankarji, Sri Gopal Singh for K-Vetar R2 and R3.
Steering they said they want to file application. Declaration and injunction. The appellant is a mentally retarded person. I sought a declaration that the sale is null and void.
You have to do. to have the benefit of interim order during pendency of this suit.
Yes, there was an interim.
Produce the certified copy. Counsel for the appellant alone present, learned counsel for the K-8 not present. As a final last opportunity, a week's time is granted to the K-8 to file their objection, if any, to IA 1/23. While in which the court may proceed further in hearing the said IA. In the meantime, you produce the separate copy of the interim order. I would have proceeded today since you don't have that copy. I am shifting the burden to the K-8 or no. She is getting one more week opportunity. Yes. List the matter. Of 3-7.
Sri Lakshmikant K. H. Ashok Kumar for K-8 R1 R2.
Suit for permanent injunction.
Yes, please. Yes. Yes.
The original owner of the measuring and 10 quintals out of 1 hectare 29 quintals. The original owner of the late one Muni and Mokka, the maternal grandmother of the plaintiff.
Have you played any interim order? Have you filed any IA for interim order? And why did you move the matter?
Property sale market.
Already property sale ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ ನೀವು interim order ಏನು ಕೇಳದೆ ಹೋದ್ರೆ ಏನು ಉಪಯೋಗ? ಕೇಳಿ interim IA ಇದ್ರೆ ಮಾತ್ರ ಪೋಸ್ಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದೀರಿ. ಹೇಳಿ ಚೇಂಬರ್ಗೆ ಯಾಕೆ ಪೋಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ? There are counsel from both sides present. Just a matter. As in normal course of listing. Yes.
TCR is required. TCR is required.
ಬರ್ಲಿ ರೀ ತಸುವ ಅವ್ರದಿನ ಸಬ್ಮಿಷನ್ ಕೇಳಿಲ್ಲ TCR ಬೇಕು ಬೇಡ ಅಂತ ಹೇಗೆ ಡಿಸೈಡ್ ಮಾಡ್ಲಿ?
Number 68, Sri Narayanan MR PD Surana for K-8 respondent.
ಹೇಳ್ಬೇಕಿತ್ತು time.
Five. Word is like, take for bidding. Only license are like. Understood that the matter will be heard. Take it down. Nala. Please on Monday. Monday. Yes, Monday.
After 12th of July, any date you can ask.
I am the afternoon, I am ready.
I have not heard matter. This matter may not be taken up for final disposal after 12th of July, but court won't say even won't affirm you that the matter will be heard as for final disposal. You will see what the matter is.
I have filed an application. They are using the property.
I have also.
One nimsham, submit.
I will see the other 25,000 to the other deposit for him on that day. And the government only investigate and complete the country.
1 second, please. 1 second.
Using the property, he has to
Yeah, 1 second.
ensure that these profits are paid to me. I got for mean profits a rate of 50,000 per month.
1 minute, please. One moment, please.
So that's what I'm going to do. Archela.
What was the relief sought for in this suit?
Suit is filed by a licensee for injunction.
Right, it was your suit.
Yes.
What the suit was for?
Was for injunction. Suit is dismissed.
There are counsel from both sides present. Just a matter of.
Earlier it was given 1 minute afterwards.
25,000 was directed.
No, it was not directed. It was not directed.
28,200. Or kindly take the order.
That was the cost awarded by the trial court. Not business property.
Order granted.
State subject to kindly see the order matter.
The next date of hearing.
Hereby state subject to appellate depositing 25,000 before this court.
ಆಗ್ಲಿ ವಕೀಲ್ರೆ ಹೇಳುವ ಮುಂದಿನ ತಾರೀಕಿಗೆ ಬರ್ಲಿ ನಾನು ಇಬ್ಬರಿಗೂ ತಾಳ್ಮೆ ಇಲ್ಲ ಅವ್ರು ಹೇಳ್ತಾ ನೀವ್ ಇಂಟರ್ಫೈರ್ ಆಗ್ತೀರಿ ನೀವ್ ಹೇಳ್ತಾ ಅವ್ರು ಇಂಟರ್ಫೈರ್ ಆಗ್ತೀರಿ ಅಂತ ಹೇಳಿದ್ರೆ ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ತದೆ ನೀವು ಸಬ್ಮಿಟ್ ಮಾಡ್ತಾ ಅವ್ರು ಸಬ್ಮಿಟ್ ಮಾಡ್ತಾ ಇವ್ರು ವಾಟ್ ದ ಸೂಟ್ ವಾಸ್ ಫಾರ್ ಅಂದೆ ಅವ್ರು ಪ್ಲೈಂಟಿಫ್ ಅವ್ರಿಗೆ ಪರ್ಮಿಷನ್ ಕೊಟ್ಟೆ ಎಸ್ ಯು ಆರ್ ದ ಪ್ಲೈಂಟಿಫ್ ಪ್ರೊಸೀಡ್ ಅಂತ ನೀವು ಮಧ್ಯೆ ಇಂಟರ್ಫೇರ್ ಆದ್ರಿ Yes.
All matters. Stage number 12. CPP Negre.
But again, in the afternoon, Learned Counsel for the appellant submits that it has paid the court fee. Yeah, please. In the registry to verify and proceed.
Stage number 37. Srimati Rachna Bharadwaj.
Ready ಮಾಡಿದ order ಇಲ್ಲಿ. ಇಲ್ಲಿ ನಾನು ತೆಗೆದು ಬಿಸಾಕಿದ್ರೆ ಇಲ್ಲಿ ಏನಾಗ್ತದೆ? Sorry. Has not kept the proper file. Yes.
Stage number 47. Communication.
ಬೆಳಗ್ಗೆ ಏನ್ ಹೇಳಿದ್ದೆ ನೋಡಿ. ಅದವ್ರು ನೋಡ್ಬೇಕಲ್ವೇನ್ರಿ? ಮತ್ತೆ ನೀವ್ ಯಾತಕ್ಕೆ ಹೇಳ್ತೀರಿ? ಎಲ್ಲಿವರೆಗೆ ನೀವು ಹೇಳಿ ಕೊಡೋರು ಇರ್ತೀರಿ, ಅವ್ರ ಕೆಲಸ ಕಲಿಯೆಲ್ಲ ಮಾಡಲ್ಲ. ಇದೆಯಾ? ಅಯ್ಯ ಕುಡಿ. Do you have any objection on this, IA?
Only request is suit and counter suit. Both were tried together and common judgment has been rendered. Kindly be heard. One appeal has been admitted, another is not admitted. Kindly be heard. It's a 2017 matter.
Which one is not admitted? One zero.
1302.
One zero three to order sheet. Both are against the same judgment. Huh?
Common judgment. Both the suits were for engagement.
Called again in the afternoon, learned counsels from both sides in both the appeal are physically present. Heard both sides on RFA 1032 of 2017 on admission. Considering the grounds raised in the memorandum of appeal, which requires a detailed consideration, RFA 1032 of 2017 stands admitted. Next one. Counsel for the opponent in P1/2021 submits no objection. Follow the said IA filed by the appellant under section 151 CPC, seeking dispensing with filing of paper. Considering the reason shown in the affidavit accompanying the application, and undertaking by the appellant that he would produce all necessary documents in court that touch upon the factual and legal aspects involved in these suits. The filing of the paper book in RFA 1031 of 2000 stands dispensed with. Accordingly, IA 1/2021 stands allowed. Yes. That registry will list it.
Number 59, Sri Ramakrishna M. Commissioner BBMP.
Called again. None appear in the matter, since the matter could not be proceeded.
Number 61, Sri GS Subbarao.
ಹಿಂದಿನ ಕೇಸಲ್ಲಿ BBMP ಕೂರಿಸಿದ್ರೆ ಯಾಕೆ ಬರಲಿಲ್ಲ ನೀವು? ಇಲ್ಲೇ ಇದ್ದೀರಿ. ಕಾಫಿ ಕುಡಿಸೋ ವಕೀಲರಿಗೆ ಮಾತ್ರ ಬರ್ತೀರಿ. BBMP ಅಲ್ವೇ ನೀವು? ಅಲ್ಲ, ಅದಕ್ಕೆ ಕೇಳ್ತಿರೋದು, ಹಾಗೆ ಬರೋಲ್ಲ ಅಂತ. ಹೋಗಿದ್ರಲ್ರಿ ಈಗ ಇವರು ಕಮಿಷನರ್ BBMP ಅಂತ. ಅದು ಎಷ್ಟು ಅನಾನುಕೂಲತೆ ಮಾಡಬಹುದೋ ಎಲ್ಲವನ್ನೂ ಅನೂಚಾನವಾಗಿ ಮಾಡ್ಕೊಂಡು ಬರ್ತಿರಪ್ಪ. Called again in the afternoon. Counsel for the appellant. Physically present. The affidavit explain the reason for non-compliance of office objection is taken on record. There was the memorandum of appeal and the June order. Issue notice to the correspondent, learned counsel Sri so and so, who is physically present as a panel advocate for respondent 1 and 2, accepts the notice for respondent number 1 and 2. He also acknowledges the copy acknowledges the receipt of the copy of the memorandum of appeal and IA 1/2020. Learned counsel prays for 2 weeks time to file his wakalat and also objection CPN to IA 1/2020. List the matter after 2 weeks. In the meantime, call for trial court records. Yes.
Other arguments, 230 matter, serial number 80, Sri Shanmukappa, Sri Ganapati Bhatt, Vajrade for Kevata respondent.
This honorable court has asked appellant why you have not filed declaration suit or counter to this original suit. Kindly see, I am producing the copy of the 2 orders passed by the trial court, which is subject matter written statement and affidavit filed by them. I have produced in this suit. Now that suit came to be dismissed, filed by them. Insofar as written statement scheduled property.
What we intend to file?
2 judgments passed by the trial court, in which the suit has been filed by the defendant, declaring that they are the owner in respect of the written statement scheduled property. ಆ suit ನಲ್ಲಿ ಅವರು adverse position ಕೇಳ್ತಾರೆ as against their vendor and BDA. In respect of same written statement suit scheduled property, which is a suit scheduled property. In that suit OS number 8962 of 2030. The permission to
Would it become production of additional documents? When very question is with respect to social property and its identity, and you are bringing some judgment which is said to have been instituted by him and according to him, the judgment therein inures to your benefit, then on its face value, it cannot be taken up, considered and relied upon. ಏನ್ ರೆಕಾರ್ಡ್ ಇದೆ ಅದ್ರ ಮೇಲೆ ಹೇಳಿ.
ಅದ್ರ ಮೇಲೆ ಹೇಳ್ತೇನೆ, ಬಟ್ ತಮ್ಮ ಗಮನಕ್ಕೆ ಜಸ್ಟ್ ಫಾರ್ ರೆಫರೆನ್ಸ್ ಅಷ್ಟೇ. ತಾವು ಅದನ್ನ
ಬರಬೇಕದು ಅಂತ ಹೇಳಿದ್ರೆ ಅದಕ್ಕೊಂದು
ಅದರಲ್ಲಿ
ನಮೂನೆ ಇದೆ.
ಆ ರೆಫರೆನ್ಸ್ ಇದೆ ಆಲ್ರೆಡಿ ವಿ ಹ್ಯಾವ್ ಫೈಲ್ಡ್.
ರೆಫರೆನ್ಸ್ ಇದ್ರೆ ಅದನ್ನೇ ರೆಫರ್ ಮಾಡಿ.
ಆ ರೆಫರೆನ್ಸ್ ಕಂಟಿನ್ಯೂಯೇಷನ್ ತಾವು ಬಿಕಾಸ್ ದಿ ಸೂಟ್ which they have filed, the BDA has taken specific attention that they are never in possession of the property which they have claimed. Accordingly, the suit came to be dismissed by the trial.
Whether that property with respect to which the BDA is said to have taken a contention that they have never been in possession of this property, is that the plain scheduled property?
No, written statement scheduled property.
Written statement scheduled property.
Yes. same property.
Then, when the very dispute is that the plain schedule property and written statement property is different,
Yes.
how for that judgment would any to benefit of either of you?
Adilla. Adre. Further prove that I am in position, they have no right and then I have taken a contention.
Mr. Counsel, in this suit, the
Yes,
court
yes,
at the
yes.
best can only say
Yes.
whether you are in possession.
Yes.
This court need not observe that he is not in possession of his scheduled property.
There is no iota of rights in respect of the property in those understanding. Andre, furthermore, ನನ್ನ ಪ್ರೂವ್ ಮಾಡಿದ ಮೇಲೆ
ನಿಮಗೂ ಗೊತ್ತಿದೆ
ಹೌದು.
ಒಳಗೆ ಇದು ನೇರವಾಗಿ ಅಪ್ಲೈ ಆಗಲ್ಲ.
ಆದ್ರೆ
ಪರೋಕ್ಷವಾಗಿ ಕೋರ್ಟ್ ಏನೋ ದೊಡ್ಡ ಮನಸ್ಸು ಮಾಡಿದ್ರೆ ಮಾಡಬಹುದು. ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅದು ಸಾಧ್ಯ ಇಲ್ಲ.
ತಾವು ಪ್ರಶ್ನೆ ಕೇಳಿದಾಗ ನಿನ್ನೆ ಕೌಂಟರ್ ಕ್ಲೇಮ್ ಹಾಕಿದ್ದೀರಾ, ಸೂಟ್ ಹಾಕಿದ್ದೀರಾ, ಡಿಕ್ಲರೇಷನ್ ಹಾಕಿದಾರಾ ಅಂತ ಕೇಳಿದಾಗ ಅಲ್ಲಿ ಏನು ಆನ್ಸರ್ ಬರದೇ ಇದ್ದ ಕಾರಣಕ್ಕೆ ಅವಾಗಲೇ ಹೇಳ್ಬೋದಾಗಿತ್ತು. ಬಟ್ ಅವ್ರು ಯಾವ್ದು ಆನ್ಸರ್ ಕೊಡ್ಲಿಲ್ಲ, ನಾವೇನು ಮಾಡ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿ, ಹಾಗಾಗಿ ತಮ್ಮ ಗಮನಕ್ಕೆ ತರುವಲು ಪ್ರಯತ್ನ. ಅದನ್ನ ಜಸ್ಟ್ ಟೇಕ್ ಬ್ಯಾಕ್, ಜಸ್ಟ್ ತಾವು ಒಂದ್ಸತಿ ಆ ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ನೋಡ್ಬಿಟ್ರೆ ಐ ಟೇಕ್ ಬ್ಯಾಕ್ ದಿಸ್, ಐ ಆಮ್ ನಾಟ್ ಪ್ರೊಡ್ಯೂಸಿಂಗ್ ಇಫ್ ಯು ಆರ್ ಲಾರ್ಡ್ಶಿಪ್ ಬೇಡ. Kindly see, yesterday that I have submitted to this honorable court, that my lord, we have established our position beyond doubt. My respectful submission, insofar as my document is concerned, my lord, kindly see Exhibit P1. Exhibit P. Before that, my lord, yesterday I have stopped. Adanu continue. Exhibit P25, 27. Adanchu ತೋರಿಸ್ಬಿಟ್ಟು ಮುಂದೆ. As a document.
Yes.
Exhibit P27, my lord, which yesterday I have submitted.
P27.
Yes, madam.
Yes.
CRP 2996 of 2003, filed by Bangalore Development Authority as against Ramaya, represented by LS, Govindra, Tukaram and Lakshmi Narayana, who are the owners, original owners, which the defendant are claiming that they have derived the title.
CRP 996 of 2003 was not filed by BDA.
Revision petition. In the revision petition 79.
Revision petition was not filed by BDA. That was filed against BDA.
RP 79. RP 79 of 2008. Page number exhibit P20.
RP is review petition.
Review petition.
Not revision petition 2996.
But in CRP ಅಂತ ಹಾಕಿದೆ. In CRP ಅಂತ ಬರ್ದಿದೆ.
ಎಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ ನಂಗೆ ದಯಮಾಡಿ ತೋರಿಸಿ ಅದನ್ನೊಮ್ಮೆ ಅಂಡರ್ಲೈನ್ ಮಾಡಿ ಕೊಡಿ ಅದನ್ನ. ಕೊಡ್ರಿ ಅವ್ರಿಗೊಂದು ಪೆನ್ಸಿಲ್. ಹೌದ್ರಿ, ಇನ್ CRP ಹಾಕಿದಲ್ಲ, ಕನೆಕ್ಟೆಡ್ ವಿತ್ ಎರಡೂ ತೋರಿಸಿದ್ದಾರೆ. ದಯಮಾಡಿ ನನ್ನ ಕೋರ್ಟಿನಲ್ಲಿ ಯಾವುದೇ ವಕೀಲರು ಅಡಿಬಿದ್ರು ಮೂಗು ಮೇಲೆ ಅನ್ನೋದನ್ನ ಮಾಡಬೇಡಿ. ತಪ್ಪಾಗಿಬಿಟ್ರೆ ತಪ್ಪು ಮಾಡೋದ್ ಮಾನವ ಸಹಜ. ನಾನು ದಿವ್ಸಕ್ಕೆ 100 ಮಾಡ್ತೀನೇನೋ ಗೊತ್ತಿಲ್ಲ. ಹೌದು ಸ್ವಾಮಿ, ನಾನು ಸ್ವಲ್ಪ ಹೇಳಿದ್ರೆ ಚೂರು ಹೆಚ್ಚು ಕಡಿಮೆ ಆಯ್ತು, ಮುಗಿದು ಹೋಗಿಬಿಡ್ತು. ನಾವು ಅದನ್ನ ಇಶ್ಯೂನೇ ಮಾಡೋದಲ್ಲ, ಅದನ್ನೇ ಜಸ್ಟಿಫೈ ಮಾಡ್ಲಿಕ್ಕೆ ಹೋದ್ರೆ ಸರಿಯಾಗಿ. ಇದು ಅತ್ಯಂತ ಸ್ಪಷ್ಟವಾಗಿ ಕ್ಲೀನ್ ಆಗಿ ಇದೆ. ರಿವ್ಯೂ ಪಿಟಿಷನ್ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಕನೆಕ್ಟೆಡ್ ವಿತ್ ಸಿವಿಲ್ ರಿವಿಷನ್ ಪಿಟಿಷನ್ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ.
ಅದೇ ಹೇಳಿ.
ನೀವು ರಿವಿಷನ್ ಪಿಟಿಷನ್ ಅಂತ ಹೇಳಿದ್ರಿ, ರಿವಿಷನ್ ಪಿಟಿಷನ್ ನಂಬರ್ನೇ ಓದಿದ್ರಿ. BDA ಫೈಲ್ ಬೈ ಪಿಟಿಷನರ್ BDA ಓದಿದ್ರಿ. ನೀವು BDA ಅಂತ ಓದಿದ್ದು, ಅವರು ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಕಾಸ್ಟ್ ರೇಟ್ ಹಾಕಿದ್ದಾರೆ, RP ಅಂತ ಅದ್ರ ಮೇಲೆ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. ಅದನ್ನ ನೀವು ಎರಡನೇ ಪುಟ ತರಿಸಿ ಸಿವಿಲ್ ರಿವಿಷನ್ ಪಿಟಿಷನ್ ನೀವಿರುವುದು ನನ್ನ ಕೋರ್ಟಿನಲ್ಲಿ. ತಗೊಳ್ಳಿ, ಕೊಡಿ, ಹೇಳಿ. ಈಗ RP ಅಲ್ಲಿಯೇ CRP ಅಲ್ಲಿ ಏನಾಗಿದೆ ಇದರಲ್ಲಿ?
ಅದರಲ್ಲಿ ಆರ್ಡರ್ ಥರ್ಡ್ ಪೇಜ್ 3. Para 2, site number 288, JP Nagar 9th Street, 7th block, Bangalore, it has been allotted.
ನಿನ್ನೆ ಓದಿದ್ರಿ ಅಲ್ವೇ ಅದನ್ನ? ಓದಿದ್ರಿ ನಿನ್ನೆ?
ನಾನು ಓದಿದ್ದೆ. ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಇನ್ ಸೋ ಫಾರ್ as 58
ಸರ್ವೆ ನಂಬರ್ 43 ಅಲ್ಲಿ ಅವನಿಗೆ ಸೈಟ್ ಕೊಡಿ ಅಂತ ಎಲ್ಲೂ ಹೇಳಿಲ್ಲ.
ಹೇಳಿ ಅಷ್ಟೇ. ಆಮೇಲೆ ಈ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇನ್ನೊಂದು ಸಿವಿಲ್ ರಿವಿಷನ್ ಪಿಟಿಷನ್ 2996 ಅಲ್ಲಿ 2003 ನಲ್ಲಿ ಅವರು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್ ಹಾಕೋತಾರೆ ಅಗೇನ್ಸ್ಟ್ BDA. ಅದರ ಅಗೇನ್ಸ್ಟ್ ಸಿವಿಲ್ ರಿವಿಷನ್ ಪಿಟಿಷನ್ 2996 of 2003 at exhibit P14, which was pending before this honorable court. ಅದರಲ್ಲಿ ಈ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾರೆ. ಇನ್ ಪೇಜ್ ನಂಬರ್ is exhibit P37 is the application. Exhibit P37 is an application filed by the respondent, the defendant, respondent, the appellant hearing. That is exhibit P37. ಆ P37 ಅಲ್ಲಿ next page ಅಲ್ಲಿ para 2 ನಲ್ಲಿ for the reasons stated in the accompanying affidavit, it is prayed this honorable court will please to implead the applicant as respondent number 2 in the above case in the interest of justice ಅಂತ ಹೇಳಿ ಪ್ರೇಯರ್ ಮಾಡ್ತಾರೆ. Then court has passed order. ಅದರಲ್ಲಿ ಈ ಸೇಲ್ ಮಾಡಿದವರು ಅಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ ಮಾಡ್ತಾರೆ. ಎಕ್ಸಿಬಿಟ್ P35 ಅವರು ಯಾರು ಸೇಲ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ, ಅವರು ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಟು ದಿಸ್ ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡ್ತಾರೆ. ಅದರ ಎಕ್ಸಿಬಿಟ್ P35. ಆ ಎಕ್ಸಿಬಿಟ್ P35 ದೇ ಹ್ಯಾವ್ ಕಂಟೆಂಡೆಡ್ ನಮ್ GPA ಫೋರ್ಜ್ ಮಾಡ್ಬಿಟ್ಟು ಅವರು CL ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡ್ಕೊಳ್ತಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. Subsequent to that, this honorable court passed order on the said IA. Kindly see, my lord, RP is a exhibit P14. Order sheet ಹಾಕಿದ್ದೀನಿ. ಅದರಲ್ಲಿ para 6, page 16. Internal page 16 of the order sheet. Exhibit P14. Are dated 26/10/2007.
Order dated
26/10/2007. Internal page 16.
Exhibit P14 is the certified copy of the order sheet in CRP 2996 of 2003.
ಅದೇ ಮುಂದುವರೆದು
Its last order is dated 27/9/2007.
ಅದರಲ್ಲಿ 16ನೇ ಪೇಜ್ ಅಲ್ಲಿ ಇಂಟರ್ನಲ್ ಪೇಜ್ 16 ಒಂದು ಆರ್ಡರ್
ಪೇಜ್ 16ರಲ್ಲಿ ಆರ್ಡರ್ ಏನಿದೆ?
ಆರ್ಡರ್ ಆನ್ 26/10/2007.
26/10 ನನಗೆ ಕಾಣ್ತಿಲ್ಲ ವಕೀಲ್ರೆ. ಇದು ಆರ್ಡರ್ ಡೇಟೆಡ್ 27/9/2007. ಕೊಡಿ ಇನ್ನವರಿಗೆ ಎಕ್ಸಿಬಿಟ್. ಒರಿಜಿನಲ್ ರೆಕಾರ್ಡ್ ಕೊಡ್ತೇನೆ ನೋಡಿ, ಅದ್ಯಾವ ತೋರ್ಸ್.
P14 D14 ಅದನ್ನು ಒಮ್ಮೆ ನೋಡಿಬಿಡಿ.
The P14. ಅದನ್ನ ಬೇರೆ ಲಾಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ ಅದನ್ನ ಆ ಪೇಜ್ ಸ್ವಲ್ಪ ಹೆಚ್ಚು ಕಮ್ಮಿ ಅವರೇ ಆರ್ಟಿಸ್ಟ್ ಕಳಿಸುವಾಗ ಅದು ಆರ್ಡರ್ ಇದೆ ಬಟ್ ಅದು ಅರ್ಧ ಪೋರ್ಷನ್ ಈ ಕಡೆ ಇಟ್ಟಿದ್ದಾರೆ ಅರ್ಧ ಪೋರ್ಷನ್ ವರ್ಷ ಕಂಟಿನ್ಯೂಯೇಷನ್ ಇನ್ CR ನನ್ನ ಕಾಪಿ P1.
ಈಗ ನೀವು ಅದೇನ್ ಆರ್ಡರ್ ಅಂತ ತೋರಿಸಿದ್ರಿ ಅದಕ್ಕೆ ಇವ್ರು ಎಕ್ಸಿಬಿಟ್ P15 ಅಂತ ಹೇಳಿ ಚೀಟಿ ಅಂಟಿಸಿದ್ರಲ್ಲ ಈ ಕಡೆ.
ಬಟ್ ಅಲ್ಲಿ
ಈ ಎಕ್ಸಿಬಿಟ್ ನಂಬರ್ ವೈಸ್ ಕೊಡ್ಬೇಕು. ಸುಮಾರು ಸರ್ತಿ ಹೇಳ್ತೇನೆ
ಹೆಚ್ಚು ಕಮ್ಮಿ ಆದ್ರೆ ಸಾರಿ
ಎಕ್ಸಿಬಿಟ್ಗಳು ಹಿಂದೆ ಮುಂದೆ ಇದಾವೆ. ಸೀರಿಯಲ್ ನಂಬರ್ ಪ್ರಕಾರ ಬರ್ಬೇಕು. ಇದೊಂದು ನೀವು ನಂಗೆ ತೆಗೆದುಕೊಡಿ ಉಳಿದಿದ್ದನ್ನೆಲ್ಲ ನಂಬರ್ ಪ್ರಕಾರ ಜೋಡಿಸ್ತೀನಿ. Yes, 26/10/2007.
Yes.
Yes.
The application file including persons who claim to have been purchased certain property from civil business, who want to get themselves included in the present civil litigation. With the petition applied against the proceedings of the execution proceeding, its case of 2002 on the file of 19th civil citizen judge Bangalore city where the petitioner were degree in their favor passed in ways number 517 of 18, but did not meet with the expected amount of success in the execution case. IA 1 of 2000 is on the premises that the subject matter of execution where the petitioner suffered an adverse order, one in which the applicants also have interest, having purchased the same part of the scheduled properties from the petitioners. It is necessary for the applicants to come on record and defend their interests by bringing this aspect of the matter to the notice of this court. So I have heard the Nalini Venkatesh, learned counsel, appearing for the applicant, Sri Govarskar, learned counsel for the petitioner, and Sri Abdul Hadar, learned counsel for the respondent. Why the basis of seeking increase in terms of the said deed executed by the in favor of the applicant by way back in the year of 1992. The petitioner are disputing the very execution of the CH-8, which is now I have brought here also. That 8996 suit also they have disputed. That the CH-8 are here fraud played by the petitioners, that the application in whose favor the power of attorney had been executed, having been found to have been misused the power of attorney. The authorization was revoked subsequently, and as regards to the measures, such persons have filed application to come on record. Therefore, application dismissed, etc. The according, assuming that the applicants are persons having derived some income from the petitioner, which itself disputed by the petitioner. It is in interest which the applicants have worked out independently and not by seeking implement in the present petition. While any such course of action as available in law is open to the applicants, the application is dismissed. My respectful submission is this. In the year of 2003 itself, 2007 itself, which statement scheduled property they are claiming, they have disputed, and no suit has been filed. Declaration of written statement scheduled property as against the vendors. This honorable court has considered objection filed by the vendors of the appellate hearing, and no document has been placed before either trial court or before this court to show that they have derived the title from the vendors of them in respect of the written statement schedule property. That's my submission. Then, my lord, insofar as, my lord, gift deed, which they have taken a contention before this honorable court, kindly see exhibit P1, which, my lord, we have produced. Exhibit P1 is the seal deed. The typed copy is there, paper book. Paper book.
Exhibit
P1. Exhibit P1 is at page, my lord, page 163 of paper book. The typed copy.
Whether it's a typed copy was not filed along with exhibit P1 in the trial court.
Trial court that we have filed, but paper book ಮಾಡುವಾಗ typed copy ಆಗ್ತದೆ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಎಕ್ಸಿಬಿಟ್ P1 ಮಾರ್ಕ್ ಮಾಡುವಾಗ ಅದ್ರದ್ದು ಟೈಪ್ಡ್ ಕಾಪಿನೂ ಅವಾಗ ಹಾಕ್ಲಿ ಇಲ್ವೇ?
ನೆನಪಿಲ್ಲ ಸಾರಿ.
ಯಾಕೆ ಇದ್ರೆ ನಾನು ಅದನ್ನೇ ನೋಡ್ತೇನೆ.
ನಾನು ಸುಳ್ಳು ಹೇಳುದಿಲ್ಲ.
ಇಸ್ಕೊಳ್ಳಿ ಅದು ಯಾವುದು
exhibit P1 in the paper. That's exhibit P1. ಇದು typed copy paper book 160. exhibit P1.
Yes.
ಇದರಲ್ಲಿ ಸನ್ ಸಾಯಿನ್ ಮಾಯನ್ ತಾಲೂಕ್ ಬೆಂಗಳೂರು ಬಸವನಗುಡಿ 1960ನೇ ಇಸ್ವಿ ಜೂನ್ ಮಾಯ ತಾರೀಖ್ 3ರಲ್ಲಿ 3/6/1960ಯಲ್ಲಿ ಮಧುಸೂದನ್ ನನ್ನ ವೆಂಡಾರಿನ ಅಪ್ಪ ರಂಗಪ್ಪನವರಿಗೆ ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ತಾಲೂಕು ಉತ್ತರ ಯಡಿಯೂರು ನಾಗಸಂದ್ರಕ್ಕೆ ಸೇರಿದ ತ್ಯಾಗರಾಜ ನಗರದ 497ನೇ ನಂಬರ್ ಮನೆಯಲ್ಲಿ ಪಾವತಿ ಮೇಲ್ಕಂಡ ನರಸಿಂಹನವರ ಮಗ ನರಸಿಂಹಯ್ಯ ಬರೆಸಿಕೊಟ್ಟ ಶುದ್ಧಕ್ರಯ ಪತ್ರ. ಇದರಲ್ಲಿ ಶೆಡ್ಯೂಲ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ವುಡ್ ಗೆಟ್ ಮೈ ಲಾರ್ಡ್ ಶೆಡ್ಯೂಲ್ ಈಸ್ ಮೈ ಲಾರ್ಡ್ ಸೊತ್ತಿನ ನಂಬರ್ ಶೆಡ್ಯೂಲ್ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ತಾಲೂಕು ಉತ್ತರಹಳ್ಳಿ ಹೋಬಳಿ ಯಡಿಯೂರು ಸೇರಿದ ಜಮೀನು ನೆಪ ಮಾತ್ರಕ್ಕೆ ನನ್ನ ಚಿಕ್ಕಪುರ ಹೆಸರಿದ್ದು 1948ನೇ ಇಸವಿಯ ಭಾಗದಲ್ಲಿ ನನ್ನ ಭಾಗಕ್ಕೆ ಸ್ವಾಧೀನ ಜಮೀನು ಪೈಕಿ ಹಾಲಿ ನಿಮಗೆ ಜಮೀನು ಚಕ್ಕು ಬಂದಿ. ಪೂರ್ವ ವೆಂಕಯ್ಯ ಅಮ್ಮನವರ ಜಮೀನು, ಪಶ್ಚಿಮಕ್ಕೆ ಸರ್ಕಾರಿ ಕರವು, ಉತ್ತರಕ್ಕೆ ರಾಮಯ್ಯನವರ ಜಮೀನು ನಂಬರ್ನಲ್ಲಿ ಜನಗಳು ತಿರುಗಾಡಲು ಇಟ್ಟಿರುವ ಜಾಗ, ಅದರ ಆಚೆ ರಾಮಯ್ಯನವರ ಸದರಿ ರಾಮಯ್ಯನವರ ಜಮೀನು, ದಕ್ಷಿಣ ಇದೇ ನಂಬರ್ನಲ್ಲಿ ಮುನಿ ತಿರುಮಳಮ್ಮನವರ ಜಮೀನು ತಿರುಗಾಡಲು 12 ಅಡಿ ಜಾಗ, ಅದರ ಆಚೆ ಸದರಿ ಮುನಿ ತಿರುಮಳವರ ಜಮೀನು, ಈ ಮಧ್ಯೆ ಇರುವ ಸರ್ವೆ ನಂಬರ್ 43ನೇ ನಂಬರ್ ಪೈಕಿ ಕುಸ್ಕಿ 1 ಎಕರೆ 26 ಗುಂಟೆ. ಇದು ಮಧುಸೂದನ್ ಅವರ ತಂದೆಗೆ ಬಂದಂತ
ಒಂದು ನಿಮಿಷ.
ಆಮೇಲೆ ಮಧುಸೂದನ್ ಅವರು ಸೇರಿ ಮಾಡ್ತಾರೆ, ರೆಫರೆನ್ಸ್ ಇದೆ ಗಿಫ್ಟ್ ಡೇಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀವಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅದ್ರಲ್ಲಿ ಇದೆ. ನಾನು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಕೊಡುವಾಗ ಕೊಟ್ಟಿದ್ದಾರೆ, ಪ್ರೊವೈಡೆಡ್ ಅದು ಇನ್ಅಡ್ವರ್ಟೆಂಟ್ಲಿ ಮಾರ್ಕ್ ಆಗಿ ರೆಫರೆನ್ಸ್ ಇದೆ ಗಿಫ್ಟ್ ಡೇಟ್ ಕೊಟ್ಟಿರೋದು. ಅದರ ಇದರಲ್ಲಿ ಅಲ್ಲಿ ಫಸ್ಟ್ ಪ್ಯಾರಾ, ಎರಡನೇ ಪ್ಯಾರಾ, ಪ್ರಾಪರ್ಟಿ ಬೇರಿಂಗ್ ಖಾತಾ ನಂಬರ್ 43 ಯಡಿಯೂರು ಉತ್ತರಲ್ಲಿ ಹೋಬಳಿ ಬೆಂಗಳೂರು ಸೌತ್ ತಾಲೂಕ್ ಪ್ರೆಸೆಂಟ್ಲಿ ಬೇರಿಂಗ್ ಪ್ರಾಪರ್ಟಿ
ಏನ್ ಓದ್ತಾ ಇದ್ದೀರಿ ತಾವು?
169 CAD ಎಕ್ಸಿಬಿಟ್ P2 ನಲ್ಲಿ
169
166 P2 CAD executed by Rangappa's children's in favor of the plaintiff.
What do you exhibit
P2. Paper book 166. Put up, sir. P2 166 paper book ಅಲ್ಲಿ
ಕೊಡಿ. Yes, P2.
Dated 9/11/2012, executed by Madhusudana, B.R. Anuradha, daughter of late Rangappa, Asha Kiran R, daughter of Rangappa, Veena B.R., daughter of Rangappa, with K. Ramakrishna Bhatt, with confirming party to plaintiff. Idರಲ್ಲಿ 169 ಪೇಪರ್ ರೆಫರೆನ್ಸ್ ಇದೆ. 3/3/1960 CAD ರೆಫರೆನ್ಸ್ ಇದೆ. ಈಗ ಮೊದಲ ಎಕ್ಸಿಬಿಟ್ P1 ತೋರಿಸಿದ್ನಲ್ಲ, ಆ CAD ರೆಫರೆನ್ಸ್ ಇದೆ. Whereas the property bearing Khata number 43 Yadiurul so Banasankari third stage Bangalore in DBMP ward number 1 originally belonged to Sri Narsimaya. The said Narsimaya has sold the property by executing registered sale deed in favor of Rangappa, while sale deed dated 3/3/1960 registered as document number so. Then, my lord, I'll not trouble reading all these things, my lord. I'll directly come to the schedule of the property, last page. Last but one page. All the piece and sir.
Yes.
All the piece and parcel of the property bearing vacant site number 18/1 4 May 70 cross Banasankari second stage, Brahat Bangalore Mahanagara Palike ward number 165, Bangalore old Khata number 43, Yadiurul Uttaralli Hubli, Bangalore South Taluk, measuring east to west, so north south. Schedule. This is property. Then, my lord, Khata. Subsequent to registration of the property, where BBMP has transferred Khata in the name of the plaintiff. I have produced
The
Khata.
contention of the defendants is that Narsimaya, the vendor to Rangappa, had no title to sell that property to Rangappa because the very same Narsimaya had already sold the very same property to Munitayamma or whosoever.
Allah, ಅದರಲ್ಲಿ according to their contention, ಅವರು ಮುನಿ ನರಸಿಂಹಯ್ಯ ಅವರಿಗೆ 7 ಎಕರೆ 25 ಗುಂಟ ಬಂದಿದೆ. ನಾವು 1 ಎಕರೆ 26 ಗುಂಟೆ ರಂಗಪ್ಪನಿಗೆ ಕೊಟ್ವಿ. ಅವ್ರು 1 ಎಕರೆ 26 ಗುಂಟೆ ರಾಮಯ್ಯ ಅವರ ತಾಯಿ ಮುನಿ ತಿರುಮಳಮ್ಮ ತಗೊಂಡ್ರು. Subsequent to that, the death of Puri Tirumalaya, Ramaya succeeded that 1 acre 20 guntas in survey number 43 of your village. Therefore, my lord, that is not the contention that Narsimhaya has no title. Narsimhaya title idri illi tanka avaru kaikondu kurudbekagilla. CLD document 1930. It's till now they have not challenged. They can't suddenly in the written statement.
No, how much of the property Narsimhaya had right to alienate?
That, my lord, he has got a huge extent of land. But ಅವರು ಅದರ ಭಾಗದಲ್ಲಿ ಅಂತ ಎಕ್ಸಿಬಿಟ್ P1 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ. ನಾನು ಹೊಂದಿದಂತಹ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ ಒಂದು ಭಾಗ, that is my lord scheduled property in exhibit P1. That is 1 acre 26 guntas. It is sold on 3/6/1960. ಅದು ಯಾವುದು ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ ಇದೆ. They have not disputed as such that 3/3/63/1960 CLD ಅವರು ಚಾಲೆಂಜ್ ಮಾಡಲಿಲ್ಲ. Written statement ಅಲ್ಲಿ ಡಿನೈ ಮಾಡಿದ್ ಬಿಟ್ರೆ subsequent CLD also admitted, ಖಾತಾ admitted, ಖಾತಾ ಇದೆ ಅವರ ಹೆಸರಿಗೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ, ಪೊಸಿಷನ್ ಇದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಆ ಪ್ರಾಪರ್ಟಿಗೂ ನನಗೂ ಸಂಬಂಧ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
ಹೇಳಿದ್ದೇನೆ ಮತ್ತು ಹೇಳ್ತಿದ್ದೀರಿ.
ಹಾ ಸರ್.
ಅಡ್ಮಿಟೆಡ್ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀರಿ ನೀವು.
ಹಾ ಸರ್.
ಎವಿಡೆನ್ಸ್ ನಿಮಗೆ ಮೊನ್ನೆ ಓದಿ ತೋರಿಸಲಾಯಿತು. ಅಡ್ಮಿಷನ್ ಅನ್ನೋದು ಏನು ಅಂತ. This is the sale deed, exhibit P1, executed by Narsimhaya in favor of Rangappa. It is true to suggest that exhibit P1 is the sale deed executed by Narsimhaya in favor of Rangappa. ಡಾಕ್ಯುಮೆಂಟ್ಗಳು ಏನು ಅಂತ ನೀವು ಏನು ಹೇಳಿದ್ದೀರಿ, ಡಾಕ್ಯುಮೆಂಟ್ಗಳನ್ನ ಅವ್ರು ಎಸ್ ಇಟ್ ಆನ್ಸರ್ಸ್ ದೋಸ್ ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಅಂತ ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ನೀವು ಅದನ್ನ ಅಡ್ಮಿಷನ್ ಅಂತ ಹೇಳ್ತೀವಿ, ಯಾವ ರೀತಿ ಇಂಟರ್ಪ್ರೇಟ್ ಮಾಡ್ತಿದ್ದೀರಿ? ಅವರು ಆ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಅನ್ನು ಅವ್ರು ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಡಿಸ್ಪ್ಯೂಟೆಡ್ ದಿಸ್ ಹೆಡ್ ಸೇಲ್, ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಡಿಸ್ಪ್ಯೂಟೆಡ್ ದಿ ಖಾತಾ, ದೇ ಹ್ಯಾವ್ ಕನ್ಸಿಡರ್ಡ್ ದಟ್ ಸೇ ಇನ್ ಅಕಾರ್ಡೆನ್ಸ್ ವಿತ್ ಲಾ ದಿ ಖಾತಾ ವಾಸ್ ಮೇಡ್ ಅನ್ನೋ ರೀತಿ ನೀವು ಅದನ್ನ ಈಗ ಡಿಪಿಕ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ.
ಆದ್ರೆ ತಾವು ಹೇಳಿದ ನಾನು ಐ ಅಡ್ಮಿಟ್ ಸಿನ್ಸ್ ಆಯ್ತು CLD ತೋರಿಸಿ ಹೇಳಿದೆ. ದಾವಾ ಆಸ್ತಿಯ ಸ್ವಾಧೀನದಲ್ಲಿ ಪ್ಲೇಂಟಿಫ್ ಇದ್ದಾರೆ ಅಂತ ಆದ್ರೆ ಅವ್ರು ಡಿನೈ ಮಾಡಬಹುದಾಗಿತ್ತು. ಅವ್ರು ದಾವಾ ಆಸ್ತಿಯ ಶೆಡ್ಯೂಲ್ ನಲ್ಲಿ ಪ್ಲೇಂಟಿಫ್ ಇದ್ದಾರೆ, ನೀವು ಇಲ್ಲ ಅಂತ ತಕ್ಷಣ ಹೌದು ಪ್ಲೇಂಟಿಫ್ ದಾವಾ ಆಸ್ತಿಯ ಶೆಡ್ಯೂಲ್ ನಲ್ಲಿ ಇದ್ದಾರೆ ತೋರಿಸಿ.
ಆದರೆ ಮತ್ತೆ ಇಟ್ ಗೋಸ್ ಟು ದಿ ಬ್ಯಾಕ್ ಟು ರೂಟ್ 1. ದಾವಾ ಆಸ್ತಿ ಕರೆಕ್ಟ್. ಎಕ್ಸಿಬಿಟ್ P1 ಪ್ರಕಾರ ನೀವು ನರಸಿಂಹಯ್ಯನಿಂದ ರಂಗಪ್ಪನಿಗೆ ಬಂದಿದೆ ಕರೆಕ್ಟ್, ರಂಗಪ್ಪನಿಂದ ನಂತರದಲ್ಲಿ ನಿಮ್ಮವರೆಗೂ ಅದು ಬಂದಿದೆ ಕರೆಕ್ಟ್, ಖಾತಾ ನಿಮ್ಮ ಹೆಸರಿಗಾಗಿದೆ ಕರೆಕ್ಟ್, ಟ್ಯಾಕ್ಸ್ ನೀವು ಕಟ್ಟಿದ್ದೀರಿ ಕರೆಕ್ಟ್. ಅದು ದಾಖಲೆಗಳ ಪ್ರಕಾರ ಅದಷ್ಟು ಇದೆ. ಅದೇ ದಾಖಲೆ ಪ್ರಕಾರ ದಾವಾ ಆಸ್ತಿ ಪ್ಲೈಂಟ್ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ನೀವಿದ್ದೀರಿ ಅದರ ಪ್ರಕಾರ ಅನ್ನೋದು ಅದು ತೋರಿಸುತ್ತೆ. ಹೌದು, ಆದರೆ ಅವರ ಕಂಟೆನ್ಷನ್ನು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಪ್ರಾಪರ್ಟಿ ಏನಿದೆ ಆ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಪ್ರಾಪರ್ಟಿನೇ ಇವ್ರ ದಾವಾ ಆಸ್ತಿ ಅಂತಿದ್ದಾರೆ. ಅದು ಅಲ್ಲ. ನಿಮ್ಮದು ದಾವಾ ಆಸ್ತಿ ಬೇರೆ ಕಡೆ ಇದ್ರೆ ಇರಬಹುದು, ಅದರದ್ದು ಸೇಲ್ ರಿನ್ಯೂ ಮಾಡ್ಕೊಂಡಿರ್ಬಹುದು, ಖಾತಾ ಮಾಡ್ಕೊಂಡಿರ್ಬಹುದು, ಕಂದಾಯ ಕಟ್ಟಿರ್ಬಹುದು, ಅದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಹಾಗಾಗಿ ಎಸ್ ಆ ದಾಖಲೆಗಳು ಇದೆ ಅಂತ ಹೇಳ್ತದೆ. ಆದರೆ ಅವರ ಪ್ರಕಾರ ನೀವು ಯಾವುದು ಡಿಫೆಂಡೆಂಟ್ ಇಂಟರ್ಫಿಯರ್ ಮಾಡ್ತಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೋ ಅದು ಇಂಟರ್ಫಿಯರ್ ಅಲ್ಲ, ಅದು ಸೂಟ್ ಪ್ರಾಪರ್ಟಿ ಅಲ್ಲ, ಅದು ನನ್ನದೇ ಪ್ರಾಪರ್ಟಿ, ನಾನೇ ಪೊಸೆಷನ್ ಅಲ್ಲಿ ಇದ್ದೇನೆ. ಅದಕ್ಕೆ ಅವರು ಅವರ ತಿರ್ತಕ್ಕಂಥ ಯಾವ್ದೋ ಒಂದು ಸೆಟ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ ತಗೊಂಡು ಬಂದು ನನ್ನ ಪ್ರಾಪರ್ಟಿಗೆ ಅಂಟಿಸಿ ಇದು ಸೋಷಿಯಲ್ ಪ್ರಾಪರ್ಟಿ ಅನ್ನೋ ಪ್ರಯತ್ನ ಮಾಡ್ತಿದ್ದಾರೆ. ಅದು ಅಲ್ಲ. ಇದು ತೀರಾ ಸಾಮಾನ್ಯರ ಆಡು ಭಾಷೆಯಲ್ಲಿ ಹೇಳೋದಾದ್ರೆ ಅವ್ರ ಕಂಟೆನ್ಷನ್ ಅಷ್ಟೇ. ಹಾಗಾಗಿ ನೀವು ತೋರಿಸಿರ್ತಕ್ಕಂಥ ಡಾಕ್ಯುಮೆಂಟ್ ಅವ್ರು ಡಿನೇ ಮಾಡಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಎಸ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಆರ್ ದೇರ್, but where is the property answering the description shown in those documents? That is his contention.
My respectful submission is this. My claim is in respect of the suit scheduled property as on the date of the filing of the suit. I am in position ಅಂತ ತೋರಿಸೋದಕ್ಕೆ ಖಾತಾ ಅಲ್ಲಿ ನಾನು ಕೇಳ್ತೀನಿ, BBMP ಅವರು ಖಾತಾ ಇಶ್ಯೂ ಮಾಡುವಾಗ ಪ್ರೊಸೀಜರ್ ಏನಾದ್ರೂ ಗೊತ್ತಾ? ಅವರು ಬಂದು
ಅದರಲ್ಲಿ ಒಂದು 4-5 ವಾಕ್ಯ ಕೇಳಿದ್ದೀರಿ.
ಹೇಳಿ
ಇನ್ಸ್ಪೆಕ್ಷನ್ ಮಾಡಿದ್ದಾರೆ
ಮಾಡಿದ್ದಾರೆ. ಅದು ಒಪ್ಕೊಳ್ತಾರೆ. BBMP ಅವರು ಬಂದು ಖಾತಾ ಇಶ್ಯೂ ಮಾಡುವ ಮೊದಲು ಬಂದು ಜಾಗ ಚೆಕ್ ಮಾಡಿ ಸ್ವಾಧೀನದಲ್ಲಿದ್ದ ಇದ್ರೆ ಮಾತ್ರ ಖಾತಾ ಕೊಡ್ತಾರೆ ಅನ್ನೋದು ಒಪ್ಕೊಂಡಿದ್ದಾರೆ. ಆ ಖಾತಾ ಅಡ್ಮಿಟ್ ಆದ್ಮೇಲೆ ಖಾತಾ ಕೊಡುವಾಗ BBMP ಅವರು ಚೆಕ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಆದ್ಮೇಲೆ ನಾನ್ ಸ್ವಾಧೀನದಲ್ಲಿದ್ದೀನಿ ಅಂತ ಅರ್ಥ. ಅದು ಬಿಟ್ಟು ಅವರು ನಾನು ದಾವಾ ಆಸ್ತಿಯ ಸ್ವಾಧೀನದಲ್ಲಿದ್ದೇನೆ ಅನ್ನೋದನ್ನ ಒಪ್ಕೊಳ್ತಾರೆ. ಇಲ್ಲ ಅವ್ರು ಹೇಳ್ಬೋದಾಗಿತ್ತು.
ಮ್ಯಾಟರ್ ಅಡ್ಜರ್ನ್ ಆದ್ರ ಮೇಲೆ ಇನ್ನೊಂದ್ ಸರ್ತಿ ಓದಿದಿರಿ ಅನ್ನೋದು ತೋರಿಸುತ್ತೆ ಅಷ್ಟೇ.
ಪ್ರಯತ್ನ ಮಾಡ್ತೀವಿ ಬಟ್ ಈಗ ನನ್ನ ರೆಸ್ಪೆಕ್ಟೆಡ್ ಸಬ್ಮಿಷನ್ ಇಸ್ ದಿಸ್: when position of the property is not in dispute, he has clearly admitted. ಅದನ್ನ ತೋರಿಸ್ಬೇಕು. Cross examination dated 18/2/2017. ಪ್ಯಾರಾ 10 ನಲ್ಲಿ ಇದರಲ್ಲಿ ಪ್ಯಾರಾ 10 ನಲ್ಲಿ it is not true to suggest that property shown in the schedule of the plaintiff is not adjoining 1 acre 20 guntas of the land of Ramaya. It is true to suggest that scheduled property is not of part of property 1 acre 20 guntas of the land held by Ramaya. Ramaya ಅಂತಂದ್ರೆ ಗೋವಿಂದ ರಾಜು, ಇವರು ವೆಂಡಾರ್ ರಾಮಯ್ಯನ ಮಕ್ಕಳು. ಮುನಿ ತಿರುಮಲಮ್ಮ, ರಾಮಯ್ಯ, ಗೋವಿಂದ ರಾಜು ತುಕಾರಾಮನ್ 3 ಜನ ಅವ್ರೇನು ಒರಿಜಿನಲ್ ಸೂಟ್ 5171 80 ಹಾಕಿದ್ರು. ಅವರ ತಂದೆ ರಾಮಯ್ಯ, ತಂದೆ ಅವ್ರ ಮಕ್ಕಳು, ಇವರು ವೆಂಡಾರ್, ಡಿಫೆಂಡೆಂಟ್ಸ್ ವೆಂಡಾರ್ ರಾಮಯ್ಯನ ಮಕ್ಕಳು. ರಾಮಯ್ಯ. It is not true to suggest that adjoining site of the scheduled property were sold by Rangappa. It is true to suggest that we are not in possession of the property described in the schedule of the plaintiff. ಅಂದ್ರೆ ಅವ್ರು ಯಾವತ್ತು ಈ ಪ್ರಾಪರ್ಟಿ ನನ್ನ ಪ್ರಾಪರ್ಟಿಯ ಸ್ವಾಧೀನದಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಆದ್ಮೇಲೆ ಐ ಆಮ್ ಆಸ್ಕಿಂಗ್ ಮೈಸೆಲ್ಫ್, ಇಟ್ ಈಸ್ ಡೀಮ್ಡ್ ದಟ್ they have not in possession of the property which is described in the plaintiff. And my lord, it is an admission saying that they are not in possession of the scheduled property. ಅವರು ಡಿನೈ ಮಾಡಬಹುದಾಗಿತ್ತು ನನ್ನ ಪ್ರಕಾರ. ಇಲ್ಲಪ್ಪ, ಇದು ನನ್ನ ರಿಟನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಪ್ರಾಪರ್ಟಿ, ಆ ಪ್ರಾಪರ್ಟಿ ತೋರಿಸ್ತಾ ಇದ್ದೀರಿ, therefore they are not, you are not in possession ಅಂತ ಹೇಳ್ಬೋದಾಗಿತ್ತು. ಅದನ್ನ ಹೇಳಿಲ್ಲ. ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಇರುವ ನನಗೆ ಪ್ಲೇಂಟ್ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಬಿಟ್ಟು ಇನ್ಯಾವುದು ನಾನು ಕೇಳ್ತಾನೂ ಇಲ್ಲ. ಹಾಗಾಗಿ ಮೈ ರೆಸ್ಪೆಕ್ಟ್ಫುಲ್ ಸಬ್ಮಿಷನ್ ಇಸ್ ದಿಸ್: ವೆನ್ ಸೇಲ್ಡಿ ಖಾತಾನು ಹೇಳ್ಬೋದಾಗಿತ್ತು ಬೋಗಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ. ಸೇಲಿಗೆ ದೇ ಶುಡ್ ನಾಟ್ ಹ್ಯಾವ್ ತೋರಿಸಿದಾಗ್ಲೂ ಕೂಡ ಇಲ್ಲ, ಅದು ಸಮಥಿಂಗ್ ಎಲ್ಸ್ ಅಂತ ಹೇಳ್ಬೋದಾಗಿತ್ತು. ಮುಂದುವರೆದು ಹೇಳ್ತಾರೆ, ಇಟ್ ಈಸ್ ಟ್ರೂ ಟು ಸಜೆಸ್ಟ್ ದಟ್ BBMP authorities before making khata visit to the property. It is true to suggest that after spot inspection, the BP would levy the tax on the property. My father has not filed any case against his vendors after making allegation of forgery. ಆ ಫೋರ್ಜರಿ ಹಾಕಿದ ಮೇಲೆ ನಾನು ಅದನ್ನ ತೋರಿಸಿ ಕೇಳ್ತೀನಿ. ಅಲ್ಲ ಆರ್ಡರ್ IA-1 ಮೇಲೆ ಆರ್ಡರ್ ಆಯ್ತಲ್ಲ ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ CRP 2996 ಅಲ್ಲಿ, ಆ ಫೋರ್ಜರಿ ಅಲಿಗೇಷನ್ ಮಾಡಿದ್ಮೇಲೆ ಏನಾದ್ರೂ ನಿಮ್ಮ ತಂದೆಯವ್ರ ಕೇಸ್ ಹಾಕಿದಾರ ಅಂತ ಕೇಳಿದ್ರೆ ಇಲ್ಲ ಅಂತ ಹೇಳಿ. I don't know whether my father filed appeal challenging the order rejection of the application in CRP. I have not inquired my father. Then, my lord,
Yes.
page 50. Para 50.
Yes.
It is not true to suggest that.
Yes.
Suggest that on 3/6/19, Rangappa purchased 1 acre 20 hectares of land in survey number 4. I do not know that the sale deed at exhibit P1 standing in the name of Rangappa. It is true to suggest that Madhusudan and others have executed sale deed produced at exhibit P2 in the name of the plaintiff. The witness value is created. I have not filed any case after coming to know that exhibit P has been created. After filing the suit, I came to know Kata of the revenue record standing in the name of the plaintiff. It is true to suggest that document D1 to D23 are not concerning to the property shown in the schedule of the plaintiff. ಅದು ಸಂಬಂಧವೇ ಇಲ್ಲ. ನಮ್ಮ ಪ್ರಾಪರ್ಟಿಯ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅವ್ರಿಗೆ ಸಂಬಂಧ ಇಲ್ಲ ಅಂತ ಆದ್ಮೇಲೆ question of claiming my property ಬರುವುದಿಲ್ಲ. That is not my submission. Even the admission. ಅವರು ಈ ಪ್ರಾಪರ್ಟಿ ಮತ್ತು ಆ ಪ್ರಾಪರ್ಟಿ ಬೇರೆ ಬೇರೆ, ಅದಕ್ಕೆ ಸಂಬಂಧ ಇಲ್ಲ ಅಂತ. Apart from that, if at all they are claiming property from 1992, if at all actually they are in possession of the property, BBMP ನನಗೆ ಖಾತಾ ಕೊಡ್ತದೆ, ಅವ್ರಿಗೆ ಹೇಳ್ತಾರೆ PDA has not issued khata in the name of my father for the above said reasons. It is not true to say I have no record to show position excluding D11. My respectful submission is our khata illa, taxpayer receipt produce ಮಾಡಲಿಲ್ಲ before any court, either in other suits, and written statement ಹಾಕುವಾಗಲೂ ಕೂಡ they have not produced any document except seal. Therefore, I have produced photographs with CD before the trial court. Encumbrance certificate that I have produced, otherly encumbrance certificate also at exhibit Millard P30. Exhibit P30. What P30? What? ಅದರಲ್ಲಿ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ P13 ಅಲ್ಲಿ ತೋರಿಸುದು ಏನು ಅಂತಂದ್ರೆ, ದಾನ ಪತ್ರ ಆಗ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ ಅವರು, ಆ ದಾನ ಪತ್ರದ ರೆಫರೆನ್ಸ್ ಇದೆ. ಎನ್ಕಂಬರೆನ್ಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ P12.
Encumbrance exhibit P13
ಅಲ್ಲಿ
13
ನಲ್ಲಿ PL ಲಕ್ಷ್ಮಿ ಮಧುಸೂದನ, PL ಲಕ್ಷ್ಮಿ ಮಧುಸೂದನ ದಾನಪತ್ರ. ನಾನು ಹೇಳೋದೇನು ಅಂತಂದ್ರೆ, from 1962 till filing of the suit we have produced document to show that we are in possession of the property. Therefore, beyond doubt, we have proved issues which is burden is on us to prove. Therefore, my respectful submission is, insofar as decreeing the suit, that apart proving my issues, we have tried to establish, and we have established before the trial court that they have no right, title, interest of the written statement property. And they have not produced any documents before the trial court or before this honorable court to show that they are in possession of the property. This is not a title suit. Therefore, my respectful submission is they are not in possession of the one written statement scheduled property. That apart, they have said written statement scheduled property and paid scheduled property are totally different. Therefore, the appeal is liable to be dismissed. That apart, nano the documents those. That is exhibit P15. ಇದರಲ್ಲಿ ನಮ್ಗೆ ಯಾವ ಪ್ರಯತ್ನ ಮಾಡಿದ್ವಿ ಇದರ ರಿಸಲ್ಟ್ ನಾ ಇವತ್ತು ತಗೊಂಡ್ಬಂದಿದ್ದೆ, ಬಟ್ ಅದನ್ನ ಆಲ್ರೆಡಿ OS ನಂಬರ್ 8902 of
8902 of
2013. That is CH-8 Jain has filed against BDMP, where the BDA seeking my lord adverse position against BDA in respect of the witness statement scheduled property. The witness statement scheduled property.
yes.
ಈ exhibit P15 ಅಲ್ಲಿ the BDA has clearly contended that the deed which the appellant is referring is concocted, created, and they have denied the title. And ultimately, the contention of the BDA has been upheld by the trial court by dismissing the suit. ಈ ಸೂಟ್ ಅವತ್ತು ಡಿಗ್ರಿ ಆಗಿರ್ಲಿಲ್ಲ, ಇದು ಎವಿಡೆನ್ಸ್ ಮಾಡುವಾಗ, ಇವಾಗ ಡಿಗ್ರಿ ಆಗಿದೆ, ಇದು ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. Since I have made efforts to bring these facts, contention of the BDA, therefore ಒಂದು ನಿಮಿಷ ಅದು 8962 of 2013 ಸರ್, ಅದು 8962 ಅದಕ್ಕೆ ಸರಿಯಾಗಿ ಕಾಣಿಸ್ತಾ ಇಲ್ಲ. ಅದೇ ಸೂಟು ಈಗ ವಜಾ ಆಗಿದೆ. ಇದು ಒಂದ್ಸತಿ ತೋರಿಸಿ ವಾಪಸ್ ತಗೊಂಡ್ಬಿಟ್ಟು ಆ ರಿಟನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಶೆಡ್ಯೂಲ್ ಅವ್ರು ಹಾಕಿರೋ ಶೆಡ್ಯೂಲ್ ಒಂದ್ಸಲ ತೋರಿಸಿ 8962 ಅದೇ ಸೂಟ್. Page 14. Statement. Para 3 of the written statement. ಅದರಲ್ಲಿ ಸೈಟ್ ನಂಬರ್ 1 33 number kuda subsequent to that they have changed. ಇದರಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ ಈ ಸೂಟ್ ಅಲ್ಲಿ 3944G ಸೈಟ್ ನಂಬರ್ 1 3944G ಅಂತ ಹೇಳ್ತಾರೆ. ಈ ರಿಟನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಪ್ಯಾರಾ 3 ನಲ್ಲಿ ಇನ್ ದಿ ಪರ್ಟಿಕ್ಯುಲರ್ ಸೂಟ್ it is submitted that the defendant is the defendant purchase site number 1 formed in survey number 43 of Meduru village. Now
Written statement, which written statement you are reading?
written statement. ಈ ಕೇಸ್ ರಿಟನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅವರು ಏನ್ ಶೆಡ್ಯೂಲ್ ತೋರಿಸಿದ್ದಾರೆ ಅದೇ ಶೆಡ್ಯೂಲ್ ಮೇಲೆ ಅಡ್ವರ್ಸ್ ಪೊಸಿಷನ್ ಸೂಟ್ ಹಾಕಿದ್ರು.
ಆ ಶೆಡ್ಯೂಲ್ ಎಲ್ಲಿ ಸಿಗುತ್ತೆ?
ಈ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲೂ ಸಿಗುತ್ತೆ. ರಿಟನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಪ್ಯಾರಾ 3.
ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಪ್ಯಾರಾ 3. ಮತ್ತೆ ನಾನು ಅದೇ ಪ್ರಶ್ನೆ ಕೇಳ್ತಿದ್ದೇನೆ. ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇನ್ OS 8962 ನ
ಹೌದು 89 ಸಾರಿ ನಂಬರ್ ಒರಿಜಿನಲ್ ಶೀಟ್ 2963 ಆಫ್ 2000.
ನನ್ನ ಪ್ರಶ್ನೆ ಅದೇ ವಕೀಲರೇ, ನೀವು ಅದಕ್ಕೆ ಮತ್ತೆ ಉಲ್ಟಾ ಹೇಳ್ತಿದ್ದೀರಿ. ಪ್ರೆಸೆಂಟ್ ಒರಿಜಿನಲ್ ಸೂಟಿನಲ್ಲಿ ಇರ್ತಕ್ಕಂತ ಶೆಡ್ಯೂಲ್ 8962 ಅದರಲ್ಲಿ ಎಲ್ಲಿ ಸಿಗುತ್ತೆ ಅಂದ್ರೆ ನೀವು ಮತ್ತೆ ಪ್ರೆಸೆಂಟ್ ಸೂಟಿನ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಪ್ಯಾರಾ 3 ಗೆ ಬರ್ತೀರಿ.
ಇದರಲ್ಲಿ ಶೆಡ್ಯೂಲ್ ಈ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಶೆಡ್ಯೂಲ್ ಇಲ್ಲಿ ಎರಡನೇ ಪ್ಯಾರಾ ಜಜ್ಮೆಂಟ್ ಇಂಟರ್ನಲ್ judgment act section 8 the facts of the case the plaintiff claimed the owner in possession of the property 39G ಆಮೇಲೆ ಡಿಗ್ರಿ ಅಲ್ಲಿ ಕೂಡ ಸಿಗುತ್ತೆ. ಲಾಸ್ಟ್ ಪ್ಯಾರಾ ಡಿಗ್ರಿ ಅಲ್ಲೂ ಕೂಡ ಅದೇ ಸಿಗುತ್ತೆ ಪೇಜ್ 58. ಡಿಗ್ರಿಯಲ್ಲಿ
ಒಂದು ನಿಮಿಷ.
ಸ್ಟೇಟ್ಮೆಂಟ್ ಸಿಗ್ತಲ್ಲ ಈ ಕೇಸಲ್ಲಿ. ಈ ಪ್ರೆಸೆಂಟ್ ಕೇಸಲ್ಲಿ ರಿಟನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅದೆಲ್ಲ ಇದೆ. ಪ್ರೆಸೆಂಟ್ ಕೇಸಲ್ಲಿ ರಿಟನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ನಮ್ಗೆ ತಿಳಿದುಕೊಟ್ಟು ಅದು ಅದರಲ್ಲಿ ಪ್ಯಾರಾ 3 ನಲ್ಲಿ ಶೆಡ್ಯೂಲ್ ಸೇಮ್ ಶೆಡ್ಯೂಲ್. Therefore, insofar as written statement claimed scheduled property is concerned, ಆ ಪ್ರಾಪರ್ಟಿಯಲ್ಲೂ they are not in possession. They have no right to get sale deed ಅಂತ BDA ಹೇಳಿದೆ and court has accepted it. ಹಾಗಾಗಿ plaintiff scheduled property ಬಿಟ್ಟು plain scheduled property ಬಿಟ್ಟು ಅವ್ರ scheduled propertyಗೂ ಕೂಡ ಅವ್ರಿಗೆ ರೈಟ್ಸ್ ಇಲ್ಲ. ಅದು forged sale deed. BDA has allotted site to someone else. They are in possession of the property. by virtue of an admission, so far as dependent documents DW 1 to 23 is concerned, your lordship cannot look into because they have said this is not pertaining to the social property. ಹಾಗಾಗಿ ಅವ್ರ ಪ್ರಕಾರನೇ ಅದು ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಸಂಬಂಧಿತ ಕಾಗದಪತ್ರ ಅಲ್ಲ ಅಂತ ಹೇಳಿದ್ಮೇಲೆ ನಮ್ಮ ಪ್ರಾಪರ್ಟಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಷ್ಟೇ ನೋಡ್ಬೇಕು ಅನ್ನೋದು ನನ್ನ ರಿಕ್ವೆಸ್ಟ್.
Yes.
Therefore, my respectful submission is for beyond doubt. We have established our position. Photographs that which we have produced, that is also on record. And we have produced many number of documents to prove that we are in position in respect of the social property. And BBMP has recognized it. We are paying tax regularly. And they have failed to establish, either before this honorable court or before the trial court, the plain scheduled property and restatement scheduled property is one and the same. Therefore, there is a dispute regarding identification ಅನ್ನುವ ವಿಚಾರ ಬರುವುದಿಲ್ಲ. That apart, ನಾನು ಸರ್ವೆ ಮಾಡ್ಲಿಕ್ಕೆ ತಮ್ಮ ತಕರಾರು ಇದೆಯೋ ಅಂತ ಕೇಳಿದಾಗ ಹೌದು ತಕರಾರು ಇದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. Apart from that, ನಾವು ADLR ಅಲ್ಲಿ ADLR ಅಪ್ರೋಚ್ ಆಗಿ ಅಲ್ಲೂ ಕೂಡ ನಾವು ನಮ್ಮ ಪ್ರಯತ್ನ ಮಾಡಿದ್ದೇವೆ. Insofar as the CTS number is concerned, that has also been considered. Therefore, my respectful submission, the admitted fact is this, according to me. Sale deed which we have produced is not disputed. They have admitted. ಇಲ್ಲ ಸುಳ್ಳು ಬೋಗಸ್ ಕ್ರಿಯೇಟೆಡ್ ಹೇಳ್ಬೋದಾಗಿತ್ತು. 1960 ಸೇಲ್ ಡೀಡ್ ಎಕ್ಸಿಬಿಟ್ P2 ಖಾತಾ ಟ್ಯಾಕ್ಸ್ ಪೇಡ್ ರಿಸಿಟ್ ನಾನು ತೋರ್ಸ್ ಕೇಳಿದಾಗ ಇಲ್ಲ ಅದು ಬೋಗಸ್ ಅಂತ ಹೇಳ್ಬೋದಾಗಿತ್ತು ಅಥವಾ ಸುಳ್ಳು ಅಂತ ಹೇಳ್ಬೋದು. ಅದನ್ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳ್ಬೋದಾಗಿತ್ತು. ಅದನ್ನ ಹೇಳಿಲ್ಲ ಅವರು ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಹಾಗಾಗಿ ನಾನು my respectful submission, that is an admission. Apart from that, suit schedule ಅಂತ ತೋರಿಸಿದಾಗ ಈ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ ಈ ಬೌಂಡ್ರಿಯಲ್ಲಿ ನೀವು ಇದ್ದೀರೋ ಅಂತ ಕೇಳಿದಾಗ ನಾವು ಇಲ್ಲ ಅಂತ ಹೇಳಿ. ಹಾಗಾಗಿ my respectful submission is appeal is liable to be dismissed by confirming the judgment passed by the trial court. I need not produce my lord judgment ಇದೆ. Admitted facts need not be proved, your lordship is aware. And judgment once prima facie or my lord, if we are able to prove the position of the property, my lord, trial court has come to conclusion by referring all the documents which is referred, and there is no any influence in the judgment, and my lord, trial court has applied its mind and passed judgment. Under such circumstances, my respectful submission is appeal is liable to be dismissed. This my lord, that judgment which they have, my lord, trial court, that my lord, they have sought adverse position against the owner which they are claiming site. Purchase site ಮೇಲೆ adverse position ಕೇಳ್ತಾರೆ.
Is pending. With respect to Khata is concerned, subsequent to denying, BBMP denying Khata, we approached the PDA to assign the separate number on one side. There, PDA assigned, then the CIT issued a CTS number to my property.
That he has challenged before the JDL, along with fixing the boundary. He has challenged before the JDL, that is exhibit D1. JDL set aside the CT number and against that we have find repetition.
The CTS number, CT. The interference ballot, VDA code survey department. Sir.
That we have challenged the line. That is still expanding. And they have been granted the operation of the D44. That is map. ನೀವೇನು ಓದ್ತಿದ್ದೀರಿ ಅದಿದ್ರೆ ಲೆಜಿಬಲ್ ಇಲ್ಲ. This note is not legible. And what it denotes?
Statement property is still vacant and it is not allowed because of all this dispute.
Now, how this note say you that meaning?
It is referred RFA. It's RFA 206 of
No, read that note again, please. Note.
Like number 3944,
3944 is not at all your site in the written statement. How can we have to infer all those things?
Yes, challenge. Even reflect that. Yes, challenge this number. I mean, see, D1.
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 Exhibit D1, where do I get the reference? No, you drew my attention to exhibit D1. In exhibit D1, where are the numbers which you are now referring to?
Also, mapping also previous number 3737. Number 37.
Yes.
Really, specifically insofar as 1 acre 26 guಂಟಸ್ ಅವ್ರ ಪ್ರಾಪರ್ಟಿಗೆ ಬೌಂಡ್ರಿ ಫಿಕ್ಸ್ ಮಾಡಬೇಕು ಅಂತ ಕೇಳಿದ್ರು. ಬಟ್ ಅವ್ರ ಪ್ರಾಪರ್ಟಿ ಏನಾಗಿತ್ತು ಅಂತಂದ್ರೆ which they have claimed CTS number by virtue of that deed which is challenged. BDA acquired and BDA has said there is some other site has been found. All these things has been brought into the court notice, ADLR notice, and ADLR has said that the granting of CTS by virtue of the position of the property in the BD in respect of the CTS number is concerned. Therefore, by granting opportunity has passed.
Yes.
Although another document to show that they are not entitled any relief. Even independent suit hakidru kuda, they can't establish that they are in possession of property.
With respect to the impleading application. The impleading application, my vendor also sold another adjacent site to my wife, that is my wife. My subsequently sold other portion of property to another third person. She has filed a declaration suit against the BDA. Also made my vendor as a party in that suit. That suit decree, that is particularly. As per the decree, BDA should execute reconveyance agreements in favor of others. Yes. Clearly shows that I have also taken.
No, that is not with respect to the suitable property, but adjacent property.
merely because adjacent property said to have got a clear title or subsequently made a clear title doesn't mean that the social property also should have.
Same day, I went to executed, that said it and I said it.
Maybe.
Because
Maybe
they have.
same day, maybe same hour with the same witnesses, but the properties are different.
Properties are different methods. And another thing methods, BDA itself accepted that my vendors are in possession of the property. That is in the judgment, it is clearly stated in RFA judgment methods. But whatever BDA is dismissed. In that judgment, it is there is a precedent showing that my vendors are in possession of property. And because the reason why we are getting against BDA and to obtain the recovery. Meanwhile, this plaintiff and disputed my title and created their own version of the title and challenging my title and tried to the person of my written statement. And so that in the cloud regarding the title, they have very things, declarations, not in the things.
Yes, you did not rely upon those judgments in the trial court. Hmm. Where he had, say, challenged or doubted or suspected the title of the plaintiff with respect to social property. No way. Yeah. Then why those judgments are? They are not at all attracted or applicable.
Also, I have disputed their title.
You are not disputing his title and he is not concerned with your title. Your contention is that he might have purchased. He might have been the owner. That is the sale deed. Yes. That is the kata. Yes. That is the tax paid receipt. Yes. He is paying the tax. Yes. Everything you have said, yes, yes, yes. Your only contention is that, but that is a separate property, not my property. Therefore, the question of you disputing his title doesn't arise here. Day one, the very first sentence I asked both of you was, in case of any dispute as to the identity of the property, what is the law and what is the procedure to be followed? ಅದು ಒಂದನ್ನು ಬಿಟ್ಟು ಉಳಿದಿದ್ದು ಎಲ್ಲದನ್ನು 5.75 ತಾಸು ಇಬ್ರು ಹೇಳಿದಿರಿ. ನೀವೇನ್ ಹೇಳಿಲ್ವೋ ಅದನ್ನ ನಾನು ಬರೀ.
One submission. Appellant's wife case ಹಾಕಿದ್ರು, declaration case ಹಾಕಿದ್ರು ಅಂತ ಹೇಳಿದ್ರು ನಾವು. ಅದು ಸೈಟ್
ಬರಲ್ರಿ ಇದ್ರಲ್ಲಿ.
ಬರಲ್ಲ ತೋರ್ಸಲ್ಲ.
ಯಾಕೆ ನೀವು ಅವ್ರೇನೋ ಹೇಳಿದ್ರಲ್ಲ ಅಂತ ಹೇಳೋದು, ನೀವೇನೋ ಹೇಳಿದ್ರಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳೋದು.
Submissions. I am extremely sorry.
Counsels from both sides present. ಕರೆಕ್ಟ್ ಆಗಿ ಜೋಡಿಸಿಡ್ರಿ ಎಲ್ಲದನ್ನು. ಎಲ್ಲ ಎಕ್ಸಿಬಿಟ್ಸ್ ಅದೇ ಸೀರಿಯಲ್ ನಂಬರ್ ಪ್ರಕಾರ ಹಾಕಿ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೇನೆ. Heard the further argument of learned counsel for the respondent and the reply by learned counsel for the appellant. Yes, my President.
Much obliged for the great patience.
Rachana Bharadwaj.
RFA 657. You are praying for extension of interim order. When was the interim order was granted to you? Was that an interim order passed by this court? Was that an interim order passed by this court granting you any relief? Was that a direction? Was that a direction? ಕೊಡಿ ಇದನ್ನವರಿಗೆ. See that, is it an interim order? Or is it a direction? So it is neither interim order nor a direction. Then on what strength you make a submission this morning that interim order granted earlier be kindly extended? Why are you making false submission, misleading the court? Apology you want to do. The highest number of apologies I am hearing from the mouth of the learned junior counsels only. ಕೋರ್ಟ್ ಬಗ್ಗೆ ಸ್ವಲ್ಪ ಜವಾಬ್ದಾರಿ ಇಟ್ಕೊಳ್ಬೇಕು. ಕನ್ನಡದಲ್ಲಿ ಇದಕ್ಕೆ ಬೇಜವಾಬ್ದಾರಿ ಅಂತಾರೆ ಸಬ್ಮಿಷನ್ಗೆ. ಎಲ್ಲಾಗಿ ಅಜ್ಮೆಂಟ್ ಮಾಡಿದ್ರ ಮೇಲೆ ಇಂಟರ್ವ್ಯೂ ಮಾಡಿದ್ರ ಮೇಲೆ ಕೈಂಡ್ಲಿ ಬಿ ಎಕ್ಸ್ಟೆಂಡೆಡ್. ನಮ್ಮಲ್ಲಿ ಇದ್ದಾರೆ ಪ್ರವೃತ್ತಿಗಳು. ಐವೋ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್. ಏನು ತಲೆ ಕೆಡಿಸ್ಕೊಳ್ಳಲ್ಲ, ಹಿಂದೆ ಇದೆಯೋ ಇಲ್ವೋ ಏನು ನೋಡಲ್ಲ. ಅವ್ರು ಕೇಳ್ತಾರೆ, ಇವ್ರು ಬರೀತಾರೆ. ಅದು ನಮಗೆ ಅಭ್ಯಾಸ ಆಗಿ ಹೋಗಿದೆ. ವಕೀಲರು ಅಂತ ಅನ್ನಿಸ್ಕೊಂಡಿರ್ತೀರಿ, ಸ್ವಲ್ಪ ಜವಾಬ್ದಾರಿ ಬೇಡವೆ? ಈಗ ನೀವೇ ಹೇಳ್ತಿದ್ದೀರಿ, ಇಟ್ ಇಸ್ ನೇದರ್ ಎನ್ ಆರ್ಡರ್ ನಾರ್ ಎ ಡೈರೆಕ್ಷನ್. ದೆನ್ ಇಂಟೀರಿಯರ್ ಆರ್ಡರ್ ಗ್ರಾಂಟೆಡ್ ಅರ್ಲಿಯರ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಂತ ಬರ್ದಿದ್ದು ಏನಾಗ್ತಿತ್ತು? ನಾನ್ ಮನೆಗೆ ಹೋಗ್ತಿದ್ದೆ, ಬೇರೆಯವ್ರು ಬರೀತಾರೆ, ನಾನ್ ಬರೆಯಲ್ಲ. ನಾನು ಯಾವುದೇ ವಿಷಯ ಮಾಡಿದಾರು ಪ್ರತ್ಯಕ್ಷ ಕಂಡು ಪ್ರಮಾಣಿಸಿ ನೋಡಿಯೇ ಮಾಡದ್ ನಾನು. ಅರೆ ಯಾವ್ಯಾವ ವಕೀಲರು ನನ್ನ ಕೋರ್ಟ್ನಲ್ಲಿ ರಾಂಗ್ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾರೆ, 10 ವರ್ಷ ಬಿಟ್ಟು ಬಂದ್ರು ನಾನು ಹೇಳ್ತೇನೆ, ನೀವು ನನ್ನ ಕೋರ್ಟಿನಲ್ಲಿ ರಾಂಗ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ದೀರಿ ಅಂತ. ಯಾಕೆ? ಐ ಗಿವ್ ಅಟ್ಮೋಸ್ಟ್ ರೆಸ್ಪೆಕ್ಟ್, ಸ್ಯಾಂಟಿಟಿ ಟು ದಟ್ ಪ್ರೊಫೆಷನ್. ಇನ್ನೊಮ್ಮೆ ಇಂಥ ರಾಂಗ್ ಸಬ್ಮಿಷನ್ ಮಾಡಬೇಡಿ, ಯಾವ ಕೋರ್ಟ್ನಲ್ಲಿಯೂ ಮಾಡಬೇಡಿ. ಎಸ್, ಕಂಟಿನ್ಯೂ.
Further arguments, stage number 69, Sri Dilip Kumar, E.S. Nagaraj, for Kevita respondent.
ಇದನ್ನ ತೋರಿಸಿದ್ದಾರೆ, ಇದನ್ನ ತೋರಿಸಿಲ್ಲ. ತೋರಿಸದಿರೋದನ್ನ ಯಾಕೆ ತೋರಿಸ್ತಾರೆ? ಪ್ರಶ್ನೆಯಲ್ಲಿ ಬರ್ತಿದ್ದಾರ ಇದೆ ಅಂತ. ಅದನ್ನ ನನ್ನ ಪರ್ಮಿಷನ್ ಇಂದ ಯಾಕೆ ಬರ್ಸಿದ್ರಿ? ಎಷ್ಟು ದುಡ್ಡು ತಗೊಂಡಿದ್ದೀರಿ ಅದನ್ನ ಬರ್ಸ್ಲಿಕ್ಕೆ? ಗೊತ್ತಿಲ್ಲ. ಅದೇ ಬರ್ತದೆ. ಎಷ್ಟು ದುಡ್ಡು ತಗೊಂಡ್ರಿ? ಇಲ್ಲವ್ರು ಇಂಥದೆಲ್ಲ ಕೆಲ್ಸಗಳು ಆಗಲ್ಲ. ಕೆಲವೊಂದನ್ನು ಬರೆಸ್ಬೇಕು, ಕೆಲವೊಂದನ್ನು ಬರ್ಸದಲ್ಲ. ಅದು ಆಯಾ ಕೇಸ್ಗಳು ಯಾವ ಸ್ಟೇಜ್ ಅನ್ನೋದ್ರಲ್ಲಿ ಹೋಗ್ತದೆ. ನಿಮ್ಮ ಮೇಲಿನ ವಿಶ್ವಾಸನ, ನಂಬಿಕೆನ ನೀವೇ ಕಳ್ಕೊಳ್ತೀರಲ್ರಿ. ಇದು ಹೇಗೆ ಬರ್ಸಿದ್ರಿ? ರಿಟರ್ನ್ ಅಂತಿದೆ. ರಿಟರ್ನ್ ಅಂತ ಅದ್ರ ಮೇಲೆ ಪೆಂಡಿಂಗ್ ಅಂತ ಇಲ್ಲಿ ಬರುತ್ತೆ. 1,00,000 ಸರ್ತಿ ಎಲ್ರಿಗೂ ಹೇಳಿದ್ದೇನೆ, ಸ್ಕ್ರೂಟಿನವ್ರಿಗೂ ಹೇಳಿದ್ದೇನೆ, ಪೆಂಡಿಂಗ್ನವ್ರಿಗೂ ಹೇಳಿದ್ದೇನೆ. ನನ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ನೀವಿದ್ರಿ, ನನ್ನ ರೆಕಾರ್ಡ್ ನಲ್ಲಿಲ್ಲ. ಕರೆಸಿ ಅವ್ರನ್ನ, ಯಾರು ನೋಟ್ ಹಾಕಿದ್ದಾರೆ, ಬರೆದಿದ್ದಾರೆ, ಎಲ್ಲ ಮಹನೀಯರನ್ನು ಕರೆಸಿ. ಎಸ್ ಪ್ಲೀಸ್. ಮೈಕ್ರೋಫೋನ್ ಯೂಸ್ ಮಾಡಿ. ಮೈಕ್ರೋಫೋನ್ ಆನ್ ಮಾಡ್ಕೊಳ್ಳಿ ಇಲ್ಲಿ. ಎಸ್
was filed late yesterday.
ನೋಡಿ, ಈಗ ಕೇಳ್ತದೆ ಅಲ್ವಾ ಸ್ಪೀಕರ್ ಅಲ್ಲಿ? ಮತ್ತೆ ನೀವು ನಿದ್ದೆ ಮಾಡ್ಲಿಕ್ಕೆ ಕೂತಿರ್ತೀರೇನ್ರಿ? ಬೇಸಿಕಲಿ ಅಡಿಷನಲ್ ಕೋರ್ಟ್ ಆಫೀಸ್ ಅನ್ನೋದು ವೇಸ್ಟ್ ಹ್ಯಾಂಡ್. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ನೀವು ಒಬ್ರು ಮಾಡಂತ ಕೆಲಸನಲ್ಲಿ ಅರ್ಧ ಜನ ಮಾಡ್ತಾರೆ. 4 ಜನ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮಾಡಿದ್ರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಒಬ್ರು ಮಾಡ್ತಾರೆ. 3,500-4,000 ಪೆಂಡಿಂಗ್ ಇರ್ತದೆ ಒಂದೊಂದು ಕೋರ್ಟ್ಗಳಲ್ಲಿ. ಇಲ್ಲಿ ಈ ಪಾರ್ಟಿ ಕೂರ್ತೀರಿ, ಈ ಪಾರ್ಟಿ ಜನಗಳು ಕೂರ್ತೀರಿ, ಕೆಲಸ ಮಾಡಲ್ಲ. ಪ್ರೊಸೀಡ್ ಪ್ಲೀಸ್. That has been returned to you.
They have not sent the endorsement.
No, when the registry has shown that it is returned, unless you refile it, there is no existence of such an IA. Right?
But the office objections.
I do not know about you filing any IA or pendency of any such IA. As per the submission made by the court officer, it appears that in the late evening an IA might have been filed by you. The registry has written that IA to you with certain office objections. Unless you refile that IA cannot be considered at all. Court officer says that with office objections, IA has been returned.
I comply with the
Proceed with the argument on main, please.
the issues.
dealt with the fact, this was the case, my lord, where in which the signature was there only on.
Last week.
The issues have been, my lord remembers it so well. The issues have been framed, my lord, properly. One is whether the burden is on the plaintiff to prove the agreement, whatever the nature of the agreement she claims to have. Then the readiness and willingness is. Then there is an issue with respect to whether it is an agreement dated 9/9/2014, that is an agreement made between the appellant 1 to the appellant 2 is valid and binding on the plaintiff. 3 is whether she is entitled to the relief of specific performance. The judge in the judgment, an order is passed even setting aside as not binding another agreement of sale, registered agreement of sale, which was entered into between the appellant number 1, certain other people, and the appellant number 2. No issue has been framed with respect to that aspect. However, the learned judge proceeds to pass an order invalidating even that agreement of sale.
Yes.
I read issues, my lord. The order which is passed, the second portion of the order, declared that the registered sale agreement dated 22/8/2014 is, and the release deed dated 9/9/2014 executed the first defendant in favor of the second defendant, null and void. No cancellation has been sought, no cancellation has been considered. In the agreement of sale dated 22/8/2014, there are other parties to the agreement, which has been executed and has been marked as exhibit P1, P2. They are not parties to this between the appellants and there is no issue formed. However, a judgment has been rendered with respect to that. My lord, I would hold that procedure is not contemplated into the rules of civil.
Yes.
With respect to the stamp duty and the act which governs this is the Karnataka Stamp Payment of Duty by means of Stamp Rules 2009. Section 20 is the application which is in forum number 3, which contains all the stamp back. Karnataka Stamp Payment of Duty by means of e-stamps. If further amendment for that, not available in the book, a very recent book, but because of the fact that one of the examples given there does not tally. Payment of duty by means of Stamp Rules 2009. E-stamp rules 2000. Rule 20. It deals with the provisions for intermediaries, but in passing, this duty which is cast upon them is also mentioned in the same rules. 20 deals with the application and the contents of that in forum number 3, which is an addendum to this rules. 22 is when the format in which the e-stamp is issued. That is annexure A1. So,
Yes.
25 deals with payment of additional stamp duty. This was in respect to the context where the defendant's contention was that she never purchased the stamp papers which were used in the agreement. And PW1 states in the examination that the stamp papers were purchased by the defendant.
Shivakumar.
PW1 says purchased by the defendant, but PW3 says it has been purchased by Shivakumar. All four sheets of them. And the reason why we pointed out this was because the description was of a bond, of the instrument was that of a bond. Lord, we're pleased to ask, there was a second description which says agreement. The definition of bond is in 2(1)AB of the Karnataka Stamp Act. Right? That includes, says that it's an obligation, an agreement to repay certain amount of money at certain point would also be an agreement. And in case of other, the description of the property is what is not normally sought for. I read that portion, but I did not mark it. Sorry, Rule 15 of the Karnataka Stamp Rules 1958 provides for provisions for improper description of an instrument and how it can be rectified, or what is the implications of an improperly described instrument. Rule 15 of the Karnataka Stamp Rules 1958.
1 minute. Rule 15 of
Karnataka Stamp Rules 1958.
Agreed.
We are reading this in conjunction with Section 27 of the Act. 15 of the Karnataka Stamp Rules.
What it says?
But it makes a provision for the cases in which improper descriptions of stamp is used. Read, my lord. When an instrument bears a stamp of sufficient amount but of improper description, the Deputy Commissioner may, on payment of the duty with which the same is chargeable, certify the endorsement of the instrument that it is duly stamped. Provided that if application is made within 3 months of the execution of the instrument, and the Deputy Commissioner is satisfied that the improper description of the stamp was used solely because of the difficulty or inconvenience of procuring one of the proper descriptions, he may remit the further payment to duty prescribed in this rule. I only draw attention, my lord, that this is the pre-e-stamping era in which the stamp papers were
How in the instant case you call it as improper description?
stamp. The paper has been by on the face of it obtained as a bond under Article 12. It is not under Article 5E1 or
It was shown you on the other day that it also uses the word agreement.
second
Description, agreement.
Second description is a sub qualification for the instrument of the first part. That is the first one.
How do you infer that? That is the reason the court asked both of you on the other day. In the description of the stamp paper, which all of them form a uniform procedure, there ought to be some guidelines or circulars or the details as to how those entries have to be entered. Both of you were requested to place that material. What is required to be filled in which column? That could have solved the problem, rather than you attempting to interpret in your manner and they in their fashion. If you show the word bond, in the very same document, beneath the word bond, they show the word agreement. Both of them are shown to be description only. So which description to be accepted? Why two descriptions? All those things has to be answered. If there are any guidelines or circulars or rule as to how those descriptions are required to be filled.
I believe I have read it rightly, but I could not exactly pinpoint. But the second description deals with description regarding the property or the subject matter of the first description of the instrument. So
sir, that must be your presumption.
I understand. I apologize.
Yes.
I
say, when you stand in a court of law, you cannot say that you could not lay your hand. Whosoever advocates say that I could not lay my hand, I am unable to convince the court on this point, faces a greater risk. Greater risk. If the same is the position with the court also, finding may not be correct. Then it depends upon the luck. Though legally you may have merit, due to the ignorance of the law on the part of the court or on the part of the council, the finding may be improper.
I have only drawn my lord's attention, my lord, because I cannot, because I do not have it right here, my lord. I remember it, but I do not know where I searched, but I will just make another attempt. But again, the onus, my lord, again, with respect to the issues, my lord, Rule 5 of the same rules, 1958 rules, deals with description of stamps. Only thing
Mr. Counsel, the plaintiff could be able to produce this document. He could be able to show this is the agreement entered into between us for the agreement of sale of a property. It has been executed by the vendor in my favor. The vendor has admitted signature. Therefore, when this document and its execution has been admitted, I am entitled. It is your contention that this cannot be called as an agreement for certain reason. You say that it is shown as the stamp paper is issued for the purpose of bond. Other side may show
The description of the document is shown in the capital letters as agreement. Against the head description, it is shown as agreement in capital letters. My case is that it is an agreement of sale. Then when you contend, or if it is your argument that there is any misdescription of the document or this misdescription of the stamp duty paid, if you invoke Rule 15, which you just now read, then onus is upon you to show that there is some such misdescription. Because your main case is based upon that.
Was an agreement of sale, it would have been classified under Article 5 subclause. Karnataka Stamp Act 1957, Schedule Article 5. E. Part 2. Specific provision has been provided under the Stamp Act. There is no reason why there could be another provision which has been
If that were to be the case, then how come the second sheet of the same document also shows it as bond as well, an agreement?
all four. Our case has been that all four have been purchased simultaneously, and in order to be used as security for the loan, which has been availed by the defendant from Shivshankar, which has again been apportioned between the plaintiff herein and her uncle, which is in a different shoe. Specific provision, if it was an agreement of sale, contemplates a minimum of 500 rupees and a maximum of 2000 rupees, subject to 0.1% of the total value.
So your document where you have admitted your signature also shows it as an agreement.
As a bond, that is, the defendant's case is she signs on a blank sheet of stamped paper. Two sheets. One that is in the written statement paragraph 3I. One is used by the plaintiff in this suit to create a document and attach it to another sheet of paper and make it an agreement of sale for purpose of this suit. Another piece of paper in which she has signed is used by Shiv Shankar in a different suit, and where he claims an advance amount of 75,000 has been paid. Here the advance amount claimed is 1,25,000. The whole total amount is 2 lakhs. And she is always under impression she has taken 2 lakhs as loan from Shiv Shankar. And the fact that he has apportioned it amongst two persons, the sum amount which she has borrowed is 2 lakhs.
So you have been canvassing what your case is. My question is, in this document, when you dispute and contend that it is shown as issued under Article 12, but beneath that there is a word agreement in the capital letter. You are yet to convince me on that point as to why it is shown as agreement. Incidentally, in the other sheet of the very same document, there also it is shown as Article 12 bond, beneath that an agreement in capital letter. So if according to you, this document is correct document, it is an agreement.
It's not our contention that that is correct. Our contention is that we have merely signed on a blank, 2 blank stamp papers, which have been purchased by Shiv Shankar. He lends money, and if it was a transaction of money lending, the document would be styled as a bond, would be under Article 12. It would be an agreement for repayment of money. And the narrations on the face of the first page of the stamp paper would tally with what is filed in the application. Would meet the requirements of a bond for the repayment of money, an agreement for repayment of money, and would be properly covered under Article 12. Because if the application is filed,
Very. Without notice and leave of the court, how you make entries in the order sheets once the files are already sent to the court? Whenever you make any insertion, whenever you continue your finding or observation or make a fresh observation in the order sheet, is it not required of you to bring the same to the notice of the lordship who is dealing with that matter, with whom the files would be? ಮೊದಲೇ ಮುಟ್ಟಾಳ್ತನ ಕೆಲಸ ಮಾಡಿದ್ದವರು ನಿಮ್ಮ ಹಿಂದಿ ನಿಂತಿರೋ ಗನಂದಾರಿ ವ್ಯಕ್ತಿ. ಅವ್ರು ಜಾಗರೂಕರಾಗಿದ್ರೆ ನಿಮ್ಮನ್ನು ಕರೆಸ್ತಿರ್ಲಿಲ್ಲ. ಅವ್ರ ಅಜಾಗರೂಕತೆಯಿಂದ ನಿಮ್ಮನ್ನು ಕರೆಸೋದಾಯ್ತು. ಹೇಗೆ ಮಾಡ್ತೀರಿ ಹೇಗೆ? ಎರಡನೇದಾಗಿ, when once you show that a particular document is returned, then where comes the necessity of dealing with that document? to you. That has been returned anyway. So unless that is resubmitted, duly complying your objections, if any, it was not required of you to mention in the order sheet, right? Your shara is not that stones or document is filed, but it is kept in abeyance or kept pending for compliance of certain thing. And the applicant or the person who has filed is notified about the same. That is not that. We have returned it. ಎಷ್ಟು ಸರ್ತಿ ದಿವಸ ಚಂಬರಿ ಕರೆಸ್ತೇನೆ, ಹೇಳ್ತೇನೆ, ಚಿತ್ರಗಳಲ್ಲ. ಯಾಕೆ? ನಿಮ್ಗೆಲ್ರಿಗೂ ಒಂದು ಗ್ಯಾರಂಟಿ, ಕರ್ನಾಟಕ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಕಳೆದ 15 ವರ್ಷದಿಂದ ಒಬ್ಬರ ಮೇಲೆ ಒಂದು ಡಿ ಅಂತ ಆಗಲ್ಲ, ಒಬ್ರಿಗೂ ಶಿಕ್ಷೆ ಆಗಲ್ಲ, ಒಬ್ರಿಗೂ ಇನ್ಕ್ರಿಮೆಂಟ್ ಕಟ್ ಆಗಲ್ಲ. 3 ತಿಂಗಳು ಬಿಟ್ಟು ಅವ್ನು ರಿಟೈರ್ ಆಗ್ತಾನೆ ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ಒಂದು ಪ್ರಮೋಷನ್ ಆರ್ಡರ್ ಇವತ್ತೇ ರೆಡಿ ಇರುತ್ತೆ, ಚೀಫ್ ಜಸ್ಟಿಸ್ ಇಂದ ಸೈನ್ ಆಗಿ ಬರುತ್ತೆ. ಹಿ ಇಸ್ ಪ್ರಮೋಟೆಡ್ ಟು ಸೋ ಅಂಡ್ ಸೋ ಪ್ಲೇಸ್ in the post which shall be or which would be vacated on so and so future date. ಅಲ್ಲಿವರೆಗೆ ನಿಮಗೆ ಗ್ಯಾರಂಟಿ ಇದೆ. ಕೆಲಸ ಯಾಕೆ ಮಾಡ್ತೀರಿ? ಮೈಂಡ್ ಅಪ್ಲೈ ಮಾಡಿ ಕೆಲಸ ಯಾಕೆ ಮಾಡ್ತೀರಿ? ಎಷ್ಟು ಸೈಟ್ ತಗೊಳ್ಳಿ, ಎಷ್ಟು ಮನೆ ತಗೊಳ್ಳಿ, ಎಷ್ಟು ಕಾರ್ ತಗೊಳ್ಳಿ, ಏನ್ ಮಾಡ್ಲಿ, ಎಲ್ಲಿ ಟೂರ್ ಹೋಗ್ಲಿ, ಯಾರ ಮನೆಯಲ್ಲಿ ಏನಾಯ್ತು, ವಾಟ್ಸಪ್ ಎಷ್ಟು, ಟ್ವಿಟರ್ ಎಷ್ಟು, ಅದರಲ್ಲೇ ಬ್ಯುಸಿ ಇರ್ತೀರಿ. ಯಾವ ಸಂಸ್ಥೆ, ಯಾವ ಮನೆ, ಯಾವ ದೇಶ ಮೂಲಭೂತ ಶಿಸ್ತಿಲ್ಲವೋ, ಯಾರು ಮೂಲಭೂತ ಪ್ರಾಥಮಿಕ ಶಿಸ್ತಿಗೆ ಗಮನ ಕೊಡಲ್ವೋ ಅದು ಯಾವತ್ತೂ ಉದ್ಧಾರ ಆಗಲ್ಲ. ಭಾರತದ ದೊಡ್ಡ ದುರಂತ ಇಲ್ಲಿ ಶಿಸ್ತಿನ ಬಗ್ಗೆ ಮಾತಾಡೋರು ಪರಕೀಯರು. ಇಷ್ಟು ಸಣ್ಣ ಪುಟಾಣಿ ಸಿಂಗಪುರ ಅಷ್ಟು ದೊಡ್ಡದಾಗಿ ಎಕ್ಸ್ಪೆರಿಮೆಂಟ್ ಮಾಡಿದೆ, ಇಷ್ಟು ಸಣ್ಣ ಜಪಾನ್ ಮೋಸ್ಟ್ ಡೆವಲಪ್ಡ್ ಕಂಟ್ರಿ ಆಗಿದೆ, ಇಷ್ಟು ಸಣ್ಣ ಫ್ರಾನ್ಸ್, ಜರ್ಮನಿ, ಗಾಳಿಪಟದ ಪೀಸ್ ಅಂತ ಇರ್ತಕ್ಕಂತಹ ಗ್ರೇಟ್ ಬ್ರಿಟನ್ ಅಂತವುಗಳು ಮಹಾ ಸಾಧನೆ ಮಾಡಿದಾವೆ. 100 ಕೋಟಿ ಜನಸಂಖ್ಯೆ ದೇಶನ 100 ವರ್ಷಗಳ ಕಾಲ ಆಳಿದಾವೆ. ಕಾರಣ ಇಷ್ಟೇ, ಅವರೆಲ್ಲರಲ್ಲೂ ಶಿಸ್ತು ಅನ್ನೋದಿದೆ. ನಮ್ಮಲ್ಲಿ ಎಲ್ಲದಕ್ಕೂ ಒಂದಿದೆ, ಎಲ್ಲವನ್ನೂ ಮಾಡಲ್ಲ, ಯಾವುದೂ ಮಾಡಲ್ಲ. ಹ್ಯುಮ್ಯಾನಿಟಿ. ಆ ಹ್ಯುಮ್ಯಾನಿಟಿ ಪದದ ಅಟ್ಮೋಸ್ಟ್ ದುರ್ಬಳಕೆ ಪ್ರಪಂಚದಲ್ಲಿ ಎಲ್ಲಾದ್ರೂ ಆಗ್ತಾ ಇದ್ರೆ ಭಾರತದ. ಇವ್ರಿಗೆ ಹ್ಯುಮ್ಯಾನಿಟಿಗೆ ಯಾವ ಶಿಸ್ತು ಬೇಡ, ಹ್ಯುಮ್ಯಾನಿಟಿಗೆ ಯಾವುದೇ ಒಂದು ರೀತಿಯ ರೀತಿ ರಿವಾಜು ಕಟ್ಟಳೆ ಅನ್ನೋದು ಬೇಡ. ಏನ್ ಒಮಿಷನ್, ಏನ್ ಡಿಲಿಷನ್, ಏನ್ ಮಿಸ್ಟೇಕ್ ಏನಾದ್ರು ಅಯ್ಯ ಪಾಪ ಬಿಡು, ಹ್ಯುಮ್ಯಾನಿಟಿ ಸರಿ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರೆ ಸಾಹೇಬ್ರು ಇನ್ಹ್ಯೂಮೇನ್. ಶಿಸ್ತಿಲ್ದ ಮಾಡೋರು ಎಲ್ರೂ ಒಳ್ಳೇದು. ಪರಿಣಾಮ ಏನಾಗಿದೆ? 40 ವರ್ಷದಿಂದ ನಾನು ನೋಡಿದ್ದೇನೆ. 1974 ಮ್ಯಾನ್ಯುಯಲ್ ಇದ್ದಾಗ ಏನಿತ್ತು ಈ ಹೈಕೋರ್ಟಿನಲ್ಲಿ, ಒಂದು ಘನತೆ, ಗಾಂಭೀರ್ಯ, ತಪ್ಪುಗಳು ಇಲ್ಲದೆ ಮಾಡ್ತಕ್ಕಂತಹ ಕೆಲಸ, ನೆಮ್ಮದಿ. ಅದು ಈಗ ಈ ಪಾಟಿ ಎಲ್ಲ ಅನುಕೂಲತೆಗಳಿದ್ರೂ ಕೂಡ, ಎಲ್ಲಾ ಕಂಪ್ಯೂಟರ್ ಬಂದರೂ ಕೂಡ ಅವೆಲ್ಲವೂ ಗಾಳಿ ತೂರಿ ಹೋಗಿದೆ. ಇಟ್ಹೋಗಿ Proceedings. Yes, you are contending it both as a bond and an agreement. You are yet to convince me as to why that has been shown as an agreement.
Agreement is for repayment of.
So we'll stop here. There is a Yoga Day celebration in the Patron in Chief Hall now. He is reminding me. Has raised a couple of important points in his argument today. He has referred to different rules, not yes. Let your colleague appraise you of those things, because in your argument you may have to meet them. Learned counsel for both sides present. Third further argument of learned counsel for the appellant in part. For his further argument followed by respondent's argument and reply. List this matter on. Tomorrow. On 22. 6/2023 and the top of the list. Yes, please.
ನಂದೊಂದು ಮೊಬೈಲ್ ಸೀಸ್ ಮಾಡಿದ್ದಾರೆ. ನನ್ನೊಂದು ಮೊಬೈಲ್ ಸೀಸ್ ಮಾಡಿದ್ದಾರೆ.
ನೀವು ಕಾಯ್ಬೇಕು ನನಗೆ ಹೇಳಲಿವರೆಗೂ. ಇನ್ನು ಎದ್ದಿಲ್ಲ ನಾನು, ಇರಿ ನೋಡಿ ಇದಿಷ್ಟು ಜನ ವಕೀಲರು ಇರ್ತಾರೆ.
ಆರ್ಡರ್ ಬೇಕು.
ಸೀರಿಯಲ್ ನಂಬರ್ 21. Learned counsel from both sides present. As spread for by them, list this matter on 3/7. Yes.
74, my lord.
Yes.
Filing memo for withdrawal, my lord.
Pudi. ಒಕ್ಕಾಲ ತೆಗೆದುವರೆಗೂ ಯಾವುದೇ ಮೆಮೊ ಬಂದರೂ ಒಕ್ಕಾಲ ತೆಗಿಬೇಕು ಅಂತ 1000 ಸರ್ತಿ ಹೇಳ್ತೇನೆ, ಮಾಡಲ್ಲ. Who appears for respondent? The counsel for the appellant has filed a memo seeking withdrawal of this appeal as having become infructuous. In view of the memo supporting submission, the appeal stands dismissed as having become infructuous. Yes.
Seventy-one. 71.
Yes.
It's a date not very next week.
Whom you appear for?
I respond. So respond.
Learned counsel from both sides present. Is this matter on 4th July? Yes, please. ತೆಗೀರಿ ಅದು ಯಾವ್ದಾದ್ರು ಶೀಟು. 4th July as paid. Entry order has not been extended on the previous hearing. On several dates of hearing, the interim order is not extended. It is also not known when the interim order was granted, but
at the time of admission.
2022ರಿಂದ 6 ಅಡ್ಜರ್ಮೆಂಟ್ಗಳು 6-7 ಡೇಟ್ಗಳು ನೋಡಿದ್ದೇನೆ, ಒಂದ್ ಕಡೆಯೂ ಇದು ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಲಿ. ವಾಪಸ್ ಕೊಡಿ.
ಕೈಂಡ್ಲಿ ಒಂದು 77 ಸೀರಿಯಲ್ ನಂಬರ್ ನಂದು ಒಂದು 77 ಇದೆ, ಒಂದು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದು ಚೆನ್ನಾಗಿರ್ತಿತ್ತು. So Lordship permits 77. Suit for declaration and possession decreed. ಅದರ ಮೇಲೆ appeal ಇದೆ. Stay ಇದೆ. Some date convenient to your Lordship. I am for the respondent.
Who is 77? Amit Deshpande.
Number 77. Deshpande.
And counsel for the appellant not present, and counsel for the respondent is appearing to video conference. Business matter on 5/7. It is made clear that no further adjournment to be granted in this matter.
5/7. 5/7.
5/7.